of 2007.
The appeal is dismissed.
For judgment item number 2, RBWPET 220 of 2010.
The appeal is review petitions. Sorry.
Supplementary list old matter item number 3.
My lord. Item 3, your lordship, is a PIL matter
Yes.
challenging the huge scale of excavation of land from the river Bhargavi. My lord. This has matter challenged in 2014, your lordship.
Tell us, sir. Tell us.
My lord, at present, your lordship, I do not have any instruction.
Counsel to petitioner states he has no instructions. Dismissed.
Supplementary list item number 4.
My lord, Mr. Mahanti elects, so kindly
Pass
take
over.
up after
All right, pass over.
Supplementary list item number 5.
May please, my lord. You know, the appellant is he was wanted as an Angodabali helper, my lord. Thereafter, an advertisement was issued. An advertisement was issued to fill up the post of Anganwadi worker. And a circular has been subsequently issued that the Anganwadi helper, those who have requisite qualification, that is HSC passed, they will be given appointment. So Lordship will find that circular under annexure. After the advertisement was made, it was came to notice, your lordship have a glance to the annexure 3, page 17, my lord. In partial modification, my lord, got it, page 17. Page 17, my lord, this is consideration of erstwhile Anganwadi helper of the sub-center of an engagement as Anganwadi worker. Sir, madam, in partial modification to this department letter of answers on the above subject, I am directed to say that while Anganwadi helper of the sub-center shall be engaged as Anganwadi worker if she has passed HSC examination. Now, shall be re-engaged as Anganwadi helper if her qualification is less than class 10. Thereafter, my lord, have a glance to next page, annexure 4, my lord. That is paragraph 3. That was issued on 4/8/2007. Anganwadi helper or community organizer who fulfills the eligibility criteria and has rendered more than 5 years of service shall be engaged as Anganwadi worker also in the scheduled area, even if she is not SC/ST. Here, my lord, as will be revealed from the annexure 1, she was appointed as Anganwadi helper in the year 99. She has requisite qualification of HSC passed. But that circular, without taking into consideration the subsequent, the circular which has been issued under annexure 3 and 4, they have issued a notification for which, my lord, even the petitioner has also applied. This appellant was appeared, but the private respondent, my lord, she was selected because she secured more mark than this appellant, my lord. So, my lord, she challenged it, and in appeal, that was remitted back, and that was challenged by the private respondent in the writ application, where this Honorable High Court, Honorable Single Judge, on 12/11/2018, has disposed of the matter. Here the problem was, my lord, on that day no advocates were present because of the cessation of war. Anyhow, my lord, the Honorable Single Judge held that since the selection, after the selection was held and he has applied, so it could not have been cancelled. And the petitioner, this appellant could not have been appointed as Anganwadi worker. But while issuing the initial advertisement, my lord, the circular under annexure 3 and 4 was not taken into consideration. And since it was not taken into consideration, and basing on the representation submitted by this appellant, my lord, the advertisement which has been issued, and even after the selection, that was cancelled. Now, my lord, Honorable Single Judge held that there is no cogent reason has been given why after selection, the selection has been cancelled and the order of appointment has been issued in favor of the appellant, my lord. Now, my lord, on that date, my lord, this point could not be taken off, and for which Honorable Single Judge has said that the ADM could not have directed for remitted the matter back for consideration. That is the this writ application which has been filed by the private respondent, my lord, that has been allowed. And even though, my lord, she has not paid for cancellation for setting aside the appointment order, but selection process has been set aside. So, in spite of that, my lord, my Honorable Single Judge has said that the order of appointment issued in favor of the appellant cannot stand in the eye of law. So, my lord, my submission before my lord is that here, my lord, basing on the annexure 3 and 4, since the petitioner was appointed in the year 99, and by that time he has already served for more than 10 years, and she is having HSC certificate. That is the reason, my lord, on the same center, she was given appointment as Anganwadi worker, my lord. This lady has been working since 99 in this.
Yes.
What permitted your lordship? The case of the appellant is she was working as an Anganwadi helper, not worker.
Right.
In Ittukura, Anganwadi Center 1.
Correct.
Now, subsequently, a new center was opened and advertisement was floated. In the advertisement, my merit list was published. In the merit list, I was number 1. Now, what they have did, they have cancelled the advertisement and have unilaterally appointed the appellant.
Then why the advertisement?
Yes, Your Lordship. That is what has been dealt by the super single judge.
Correct. That's what he's. What is the reason for cancellation of the advertisement is not clear.
Yes, Your Lordship. Now, Your Lordship, kindly see page 23. The second paragraph, OP number 6 was implemented as a party to the petition.
Yeah, she never filed a counter also.
Yes, Your Lordship.
No, we have not filed.
Then where's the question? You see the challenge in the present.
Now, why not if it can be remitted matter back again.
Back and forth. Everything
now
has to come to an end, sir. Your good run has to come to an end.
Now
You continue for 20 years now. Let
Yes,
others be given a chance.
Now I not see that why my instruction is that a private opposite party has not no interest.
Correct.
Anyhow, why not?
Correct.
So why not kindly?
I got the instruction today morning.
Yes,
How
and
can
then,
this-
no, that maybe. But anyhow, why not, Your Lordship? But this is my case. I have been continuing since 99 there.
That's all.
And
That's your strongest point. There's no other point. All right. The challenge of the present appeal is to an order dated 12th November 2018 passed by the learned single judge allowing writ petition civil 22890 of 2011 filed by respondent number 6 herein, whereby she questioned the cancellation of an advertisement for the appointment of Anganwadi worker bracket AWW at the Itukura 2 Anganwadi Center bracket AWC under the Mahanga block, district Cuttack, pursuant to which respondent number 6 had in fact as AWW. Paragraph by the impugned order, the learned single judge has come to the conclusion that there was no valid reason why the advertisement should have been cancelled, and thereby set aside an order passed by the additional district magistrate bracket ADM on 30th May 2011, in an appeal filed by the present appellant, remitting the matter to the selection committee for a fresh selection by issuing a fresh advertisement. Paragraph. The background facts are that in the Podamarai Gram Panchayat under Mahanga block, a new AWC was created in the name of Itukura 2 AWC by including some 5 villages. Full stop. A notification was issued on 30th April 2010. A notification / advertisement was issued on 30th April 2010 for engagement of AWW in the said center. Paragraph. Both the present appellant and respondent number 6 applied. It may be mentioned that the present appellant was working as an Anganwadi helper. Where was she working as an Anganwadi helper?
same center, same Itukura.
Actually, Itukura Anganwadi Center 1.
Yes.
In Itukura, Anganwadi AWC 1. Paragraph. On 15th May 2010, a provisional merit list was published in which respondent number 6 secured the first position. Full stop. For reasons not clear, the advertisement dated 30th April 2010 was cancelled by an order dated 30th June 2010. And an intimation was sent to the ADM Cuttack to engage the present appellant as AWW in respect of the Itukura to AWC. Full stop. Although respondent 6 challenged the said decision before the ADM, by the order dated 5th May 2011, the ADM directed the sub-collector, who was the chairman of the selection committee, to go in for a fresh selection. Paragraph. It is the said order of the ADM which was challenged by respondent 6 in the aforementioned writ petition civil 22890 of 2011. Paragraph. The learned single judge noted that the present appellant, although included in the writ petition, did not file any counter affidavit. On the basis of the available pleadings, the learned single judge found that no reasons were disclosed why the advertisement dated 30th April 2010 has been cancelled, and why the selection process that had validly proceeded pursuant thereto, with the merit list being published on 15th May 2010, should not be given effect to. So, in the circumstances, the order of the ADM was set aside and a direction was issued to proceed in terms of the merit list prepared on May 2010. Paragraph. Learned counsel for the appellant was also unable to point out to this court what reasons weighed with the authorities to cancel the advertisement dated 30th April 2010 when a validly prepared merit list was published on 15th May 2010 and with nothing being found erroneous with such list. So, apart from saying that the present appellant has been working as Anganwadi helper since 1999, there appears to be no particular reason why the advertisement dated 30th April 2010 should have been cancelled. Paragraph. The mere fact that the appellant may have continued as Anganwadi helper does not ipso facto create any vested right in the appellant to be selected as AWW and to continue as such. Full stop. This court is also unable to appreciate what factor made with the authorities to cancel the advertisement. The counter affidavit filed in the present appeal by the CDPO, Mahanga, also throws no light on this aspect. Consequently, the court is unable to find any error having been committed by the learned single judge in setting aside the order dated 30th May 2011 of the ADM and directing the authorities to proceed with the merit list validly prepared on 15th May 2010 pursuant to the advertisement issued on 30th April 2010. So this would mean that respondent number 6 is now appointed as AWW pursuant to that list. Full stop. The appeal is accordingly dismissed. No orders is to pass. The interim order is vacated.
Item number 6.
Item 6 is no instruction, my lord. Item 6, no instruction, my lord.
No instructions dismissed.
Item number 7.
Item 6, name of Mr. Ratha may kindly be recorded.
Right.
Item number 7.
None appears dismissed.
Item number 8.
None appears dismissed.
Item number 9.
petitioner challenge the order of the single judge. Right answer is page 19.
So what's the delay, sir?
There is a delay of 28 months.
Good way of putting it, sir.
Beg pardon?
Good way of putting it in terms of months.
28 months.
That's a very good way of putting it.
Sir, due to lack of communication between the previous conducting council and the petitioner, for whom the petitioner could not prefer this read of, they don't have taken.
All right.
And
All right. There's a delay of 8.
I may be pardoned, my lord. I may be pardoned, my lord. Item number 7 may kindly prayer for time to that because I am suffering from asthma.
So we are not able to see you. We are not able to see you, sir.
My lord, 2 to 3 days time may kindly be granted.
Kindly switch on your camera, sir. If you do not mind, we'd like to see you.
My lord.
Counsel, the appellant is stated to be unwell.
My lord, item
13th
number
March.
7 may kindly be.
Item number 9,
Given the date.
30th March, item number 7.
No, 13th March. 1-3.
13th March.
sir, that is a 28 months delay to file.
Item nine.
There's a delay of
60 days.
860 days in filing the present appeal. The reason advanced for the delay is that the appellant could not contact the previous counsel who was conducting the case. This excuse, according to the court, is not a valid one, as it was expected of the appellant to regularly follow up with his lawyer regarding the status of the case. Full stop. Consequently, the court is not inclined to condone the delay, extraordinary delay, in filing the appeal. IA is dismissed. Consequently, the appeal is dismissed.
Supplementary list, item number 10.
Matter became infructuous.
Infructuous dismissed.
My lord, I am for the respondent number 1 in that case.
All right.
Item number 11.
None appears dismissed.
Item number 12.
On behalf of Mrs. Mohanty, I think sometimes she is suffering from fever, my lord.
All right.
Opposite
Counsel, the appellant is stated to be unwell. Appellant.
Opposite pedal.
So who's for the appellant?
Nobody is there.
None appears for the appellant. Dismissed.
Item number 13.
None appears dismissed.
Item number 14.
Lord, 14, Lord, this litigation started with a very innocuous prayer. My mutation case was pending. I came up to your lordship saying that kindly be directed to be disposed of. The petitioner is a cancer patient, wanted to dispose of the property. So therefore, but the learned single, at that point of time, when mutation was moved, that point of time, this settlement operation was stalled. And the matter was given to the jurisdiction of the Tahsildar. Tahsildar refused to proceed with the matter, saying that the records are available with the Vigilance Department. I came up to your lordships, Lord. Lord, the Honorable Single Judge, Lord, your lordship sees page 27 on 2 counts has rejected, has refused my prayer. Lordship sees paragraph 7. From the counter affidavit, it is evident that the brothers of the petitioners alienated huge chunk of area in favor of so and so, falsely projecting the kisam of the land. The suit
What is the status of the investigation?
Let's see the Vigilance Department. They have a different panel of.
No, it's, I mean, audible to a lordship. I appear for the Vigilance Department.
What's the status of the investigation, sir?
If a lordship give me a breathing gap of 1 day, I'll come.
Counsel for the Vigilance Department needs time to inform the court of the status of investigation.
My lord.
At his request.
Lordship may indicate the case number, page 26 of a lordship brief, lords. The special judge Vigilance Cuttack and TR case number 8 of 2018.
So that you are a very eminent counsel, sir. You can advise your department what the number is.
I'll get it.
Yes. An affidavit be filed by the Vigilance Department to that effect before the next date.
14th March.
Item number 15.
14th March, my lords.
Item 15.
None appears dismissed.
Supplementary list item 16.
My lord, due to some severe cold, my lord, I am in a medical, my lord.
All right. Counselor, the appellant is stated to be unwell. List on 28th March.
My lord, item 13 also same, my lord. 13 and 16, 2 matters are my, my lord.
All right.
Item number 17.
Made to you. Here is the honorable appellant, my lord, and challenge the honorable single judge order elected as 7/12/2018.
Yes, sir.
The very Nehru campus lordship may examine the same. Now we are completing trial and she was assaulted to a 8 years girl in the time of force. Thereafter he was proceeded under trial, and after that he has availed the appeal and revision. Then he come to this honorable single judge by challenging the same order. It was confirmed. My honorable single judge passed that order that he cannot liable the same because this it is section 47 is barred. May I just but other side didn't appear. My lord, issue notice and DSA Act item for section 46 and 47. Let me see. May I pass on the? We have quoted in the it itself. Page 28 judgment. Let me see. Internal page 9, running page 28 of the.
Yes.
Then 46. May I read?
Yes, please.
Civil offense. Subject to the previous of the section 47 may subject to the provisions of the section 47, any person subject to this act who at any place in and or beyond India commits any civil offense deemed to be guilty of an offense against this act, and if charged herewith under the section shall be liable to be tried by the security force court, and on the conviction be punishable as follows at this day. Then A, B is there. Let's me come to 47.
Who's appearing for the respondent?
The respondent no appear. That's why non as appear issue. That's why issue notice. Non appear notice was served. Noting is coming that ready not written back. Neither ready nor
take steps, sir. He said respondent has not yet been served. The current present address of the respondent be ascertained by the appellant and furnished to the registry within 4 weeks. Thereafter, fresh notice returnable. 28 March.
Well, I don't know the interim order. If they are not, if they are, then Narsi may extend it.
No contempt file, nothing, sir.
Is Judge Naik appearing in the Narsi?
No, there is no interim order. You can condone the delay.
I will take fresh step. May I take fresh step?
Yes, that's what we've ordered, sir.
Judge Naik is appearing in the Narsi.
All right.
Item number 18.
Oh. May I please, your lordship? Well, this writ appeal is directed against the order of the Honorable Single Judge, dated 8/3/19. Well, the writ petition was filed challenging Annexure 3, that is an order of eviction purportedly passed by the sub-collector, which was communicated by the Tahsildar. And I challenged the very jurisdiction because as it appears from Annexure 3, the land belongs to, it is an endowment, Hindu religious endowment. So my humble submission that neither the sub-collector nor the Tahsildar has any jurisdiction because separate authorities and separate proceeding is there in the OHRE Act.
I am appearing for some of the opposite parties. The dispute is he has constructed a house, he has purchased some land. The allegation he has encroached the road. So others are not able to enter into their property. It is on the front. So thereafter, on the basis of the notice by the Tahsildar, this proceeding was initiated.
No, but does Tahsildar have jurisdiction? That's the question, sir.
No, the passage, the Tahsildar has found out.
Who will does he have jurisdiction?
Yes, my lord, have to find out a passage to the other plot. Who will find out, my lord?
No. Which is the act which is being invoked and what is the authority under that act? That's the short question.
Endowment. He has purchased the properties from the endowment. If he is possessing excess land or they encroach the road beyond his jurisdiction, then other purchasers are not able to enter into the land. That is the whole difficulty, my lords.
Then that is a matter for the civil court to decide, my lord.
No,
Tahsildar in a summary proceeding without
Tahsildar can measure the land.
Sir, please.
What
Please,
property
sir.
he has.
Sir, Annexure 3 to the writ petition, your lordship may kindly have a grant. I am sorry, my lord, that is in Odia.
Let it come on some other day. I will give you English translation of it and then I will.
Mr. Shaktidhar Das, Learned Counsel, appearing on behalf of?
I am appearing for opposite parties 4 to 11.
Respondents 4 to 11. States that he will place on record the translated copy of Annexure
3.
All the annexures have been translated copies.
No, D by 3 must be. Annexure D by 3 to the counterpart, which is a copy of the field inquiry report.
My lord, may I submit one thing, my lord? He remanded the matter to the Tahsildar.
But he says the Tahsildar has no jurisdiction.
That he can raise that point before the concerned authority.
My friend has filed a counter, a copy may be served on.
It is only a remand order if he has got some point that jurisdiction. All the points your lordship is directing in other cases also. All the points, including the jurisdiction point, he is entitled to raise before the concerned authorities, and he will decide.
That one way, and status quo will continue.
And status quo is continuing. That is the order of the single judge.
Your lordship may protect the status quo.
No.
All right. You say the challenge in the present petition, present appeal, is to an order dated
8/3/2019.
Yeah, 8 March 2019, passed by the learned single judge, declining to interfere in the writ petition civil 156 of 2017 filed by the present appellant, questioning an order passed by the Tahsildar Denkanal on the objection raised by the contesting respondents 3 to 14. No, 4 to 11. On whether there had been an encroachment by the present appellant in plot number 4151, Khata number 3470/635 of Denkanal town. Paragraph. The objection raised by the directing notice to issue in the present writ appeal on 16th April 2019, this court directed status quo as regards possession to be maintained by the parties. Paragraph. Counsel for the appellant raises the issue regarding jurisdiction of the Tahsildar to entertain the objection filed by the respondents 4 to 11 on the ground that the property in question belonged to the endowment department. Paragraph. The question whether the Tahsildar has jurisdiction to entertain the objection can also be raised before the Tahsildar himself by the appellant. Full stop. In that view of the matter, the court is not inclined to interfere with the impugned order of the learned single judge. Full stop. The parties will now appear before the Tahsildar on 2nd January 2023. It will be open to the appellant to raise all the issues, including the issue concerning jurisdiction before the Tahsildar in accordance with law. Tahsildar is requested to proceed with the matter and dispose it of
within 1 month.
Within a period of 1 month. Yes, from the aforementioned date. Till disposal of such matter, the status quo order passed by this court on 16th April 2019 will continue.
That was also given by the Honorable Single Judge. He has remanded the matter with a direction that till the matter is disposed of by the Tahsildar, status quo will continue.
Right.
Last but one para, that is the direction.
All right. The writ appeal is disposed of in the above terms.
Item number 19.
No, so 19. No, this is filed against the judgment. This is a common judgment
passed by the single judge on dated 26/2/2019. One writ appeal has been listed today, and certified copy has been filed in the analogous writ appeal, my lords. So we have filed dispensing petition.
What is this analogous writ appeal? What is that?
My lords, that is writ appeal 176 of 2019 against.
When is it coming up?
That has not been listed. It has been listed. My lords, actually in that writ petition, the petitioner challenged the cancellation of allotment and the.
Just along with writ appeal 176 of 2019 on. Second March 2023.
Item number 20.
May it please, my lord. The order passed by the Honorable Single Judge, Annexure 1 at page 18, is under challenge, my lord. The opposite party was the petitioner before the Honorable WPC number 21835 of 2011, my lord. There, the case of the opposite party was that he applied for the post of a sub-staff under the LIC, and the required qualification for appointment to the post of sub-staff was that he must be at least class 10 pass and within the age of 25 years, my lord. In order to procure this said appointment, the opposite party number 1 filed the certificate issued by a school, my lord, that is called Panchayat High School, my lord, showing his date of birth as, that is in 1966, 29/11/66, so that he will be able to come into the consideration zone.
So have you implemented the order of the learned single judge?
No, my lord.
Why not, sir?
Because, my lord, because he is not eligible for appointment, my lord.
So there is a direction by the single judge.
Yes, my lord.
How can you not implement it?
My lord, I have challenged that order here.
Is that correct position in law, sir? Challenge to the impugned order will mean that you do not have to implement it.
Once I, my lords, implement the entire.
So what should you do, sir? You have such a vast experience. You are such a reputed senior counsel.
My lord.
What should happen, sir? When you file a writ appeal?
Yes, my lord.
And there is no stay granted. What should happen, sir?
My lord, the direction was for consideration, my lord.
Sir, what have you done?
My
there
lord.
Is no stay of the impugned order of the single judge.
Yes, my lord.
What have you done, sir?
Your lordship, kindly see at page 32. What is the direction of the Honorable Single Judge? In view of the such position, this court is of the considered view that the disciplinary authority has exceeded its jurisdiction in coming to a conclusion that the petitioner stands in a different footing from Ramanath Lakra and Stephen Khallo, when the division bench of this court had already held that they taken a view that the petitioner stands on the same footing with Ramanath Lakra and Stephen Khallo. Thereby, the order dated 25/3/2021 passed by the district authority, taking a view contrary to the judgment dated 23/11/10, rendered by the division bench of this court in OJC number 1872 of 2001, cannot sustain in eye of law. The same is liable to be quashed and accordingly hereby quashed. The matter is remitted back to the very same disciplinary authority to reconsider the case of the petitioner in the light of the case of the Ramanath Lakra and Stephen Khallo and take a decision on the basis of the finding arrived at in those two cases, so far as back wages are concerned, etc., my lord. The authority considered, they found that this case is not in the same footing because
where is the order, sir? Pursuant to this direction, the order passed, do you have a copy?
My lord?
Just ask.
You have copies of the other writ petition, basing on which.
Yes, my lord. Those.
Authority, what has he passed? Disciplinary authorities pursuant to this direction.
Your lordship wanted to know what is the action taken by the disciplinary authority after this order was passed. Yes, my lord. Order has been, I'll place it.
When was the order passed?
My lord.
When was that order passed?
As far as my specific instruction go, my lordship.
When was that order passed, sir?
My lord, I have to get instruction on that.
You better find out, we'll pass it over. You're passing it over, you better find out when the disciplinary authority passed the order pursuant to this direction.
Can it be taken tomorrow?
No, sir.
Because
pass over. Just by a mobile phone call, you can easily find out. Sir. Pass over.
Right. Item 21.
Okay.
Item number 21.
May get the order passed by the Honorable Single Judge, my lord, which under challenge, my lord. My lord, the dispute is regard to the my lord, the dispute is with regard to liability of the financier to pay the taxes, my lord, after the vehicle was disposed of, and where the auction purchaser had agreed and given an undertaking that he will take all the tax liabilities, my lord. My lord, we raised when a notice was issued by the tax recovery authority, my lord. We brought to notice of the said authority that this is the liability has been transferred to the auction purchaser, but he refused to issue any notice and held that we are liable to pay that tax. And subsequently, the appeal we preferred before the commissioner also, that was also disposed of in this file, for which we had preferred this read petition. In the read petition, you'll also will find at page 12, though the Honorable Single Judge has been pleased to hold that as such, the financier is liable to pay the tax vehicle during the period when it was repossessed. We agree for that the period so far it was in our possession, we are ready to pay for the period. But after that, when we have transferred the vehicle and the auction purchaser has agreed with an undertaking that we will take all tax liabilities, that part has not been taken into consideration and the petition has been dismissed.
What has happened in the meanwhile? Have you paid the entire tax?
No, my lord, your lordship, there was the interim order. We had deposited that amount, my lord, 1,25,000.
What is that amount, sir? There's nothing.
In the
where is the interim order, sir? Tell us.
In the read petition, my lord.
No. In the writ appeal.
Read appeal, there is no order, my lord.
Then what have you done?
Well, we had already deposited the tax that as per the direction passed by the Honorable Court in the read petition. Thereafter, we have preferred this read appeal, my lord.
No, so what is the big? We can leave the question of law open. Since the tax amount involved is just rupees 1,25,000, which is not much considering the.
No, 1,25,000 tax amount was more. 1,25,000 we had deposited. There was a direction by the Honorable in the read petition that we have deposited. The liability.
After that, you lost the writ petition, sir, correct?
My lord.
This was more than 3 years ago. What have you done in the 3 years?
Oh, my lord, there's nothing we have, since we have prepared the read appeal, my lord.
It's a very nice thing. Actually, in Orissa High Court, we have a very different system from other high courts in the country. If there's an order of the single judge, which you're unhappy with and you file an appeal, whether you get stay or not, you do not have to implement it.
Well, they are a recovering officer, their authority, they are taking steps for.
What steps have they taken, sir, in your case?
That since it's pending, my lord, that instruction I don't have.
Then we can't help you, sir. Since the tax amount involved does not appear to be substantial. And since the finding of the learned single judge is that the appellant is in any way liable to pay tax for the vehicle in question during the time when it repossessed the vehicle, the court finds no reason to interfere. The writ appeal is dismissed.
Item number 22.
May I pray one thing, my lord? Your lordship, can we be permitted to, my lord, that honorable single judges have been pleased to hold that the period for which we are in possession, we are liable to pay. We are ready to pay for that. But ultimately, the appeal writ petition has been dismissed.
Right.
So therefore, my lord.
Nothing, sir. There's nothing in the matter. Right.
Item number 22.
None appears for the appellant dismissed.
Item number 23.
May I please?
Yes, please.
The appellants herein have challenged the order of Honorable Single Judge, wherein the Honorable Single Judge has redecided an issue which has already been decided by Honorable Single Judge of this Honorable Court, which I have annexed at Annexure 4. My lord, kindly come to Annexure 4, page 32. The relevant portion at page 39. Paragraph 9. The only issue involved herein is that the vendor of the predecessors of the appellants is Rajgond or Gond, and that Rajgond whether that Rajgond comes under the scheduled caste tribe or scheduled tribe or not. My lord, the Honorable Single Judge in this judgment has vividly held that Rajgond was not inserted in the scheduled tribe at the point of time when this the cell deed was executed in the year 1972. That was only in the year 2003 that was inserted under the scheduled tribe list. My lord, kindly come to paragraph 9 of page 39. My lord, basing on this, the Supreme Court judgment, the Honorable Single Judge has rendered the judgment of this. My lord, may I kindly read the relevant portion?
Yes, please.
In Millen and others, the question arose before the Constitution bench that whether it is permissible to hold inquiry and let in evidence to decide or declare that any tribe or tribal community or part or group within any tribe or tribal community is included in the general name, even though it is not specifically mentioned in the entry concerned in the Constitution, Scheduled Tribes Order 1950. The Apex Court held it is not at all permissible to hold any inquiry or let in any evidence to decide or declare that any tribe or tribal community or part of or group within any tribe or tribal community is included in the general name, even though it is not specifically mentioned in the Constitution, Scheduled Tribes Order 1950. The Scheduled Tribes Order must be read as it is. It is not even permissible to say that a tribe, sub-tribe, part of or group of or any tribe or tribal community is synonymous to the one mentioned in the Scheduled Tribes Order if they are not
to a larger bench. If the single judge was differing from the earlier single judge judgment, that's a coordinate bench. Yes. Then it has to go to a larger bench.
My lord,
that should happen. You say notice here. You accept notice for?
The private respondent is there.
I know. You accept notice for
1, 2, 3, 4.
Yeah, 1 to 4. Notice will now issue to the remaining respondents. Returnable 28th March.
That's status quo order of the suit properties.
Notice on stay. Now 3 years, nothing has happened.
Item number 24.
May I please, Your Lordship? I'll just point out certain developments because that may be necessary as to whether Your Lordship will be inclined to interfere in the matter or not. But the wife filed a writ petition for the Honorable Court saying that there is an insurance policy of the deceased husband which I am entitled to receive along with my mother-in-law, though the father-in-law is a nominee and cannot be termed as a class 1 heir in terms of Section 8 of the Hindu Succession Act. Now
You're the wife. You're the wife.
I am for the wife appellant, for Your Lordship. Now, unfortunately, the petition got dismissed. Restoration application was filed. It was barred by limitation. In fact, the list was missed, but that was not accepted. Honorable Single Judge has been pleased to dismiss my writ petition and that restoration application. That is how the writ apply has been filed. Now, the development is, pursuant to the notice, my learned friend is appearing both for the father-in-law and the mother-in-law. He says that he has, if the daughter-in-law takes the amount because she is staying separately with the son and having no employment, is finding it difficult to rear him up because the education and other things are there. In this context, I humbly pray if Your Lordship will be inclined to interfere because in writ petitions, the Honorable Court had the occasion to interfere in these kind of matters where there is no dispute. If there is a dispute, then the party has to go to the common law forum, namely status or entitlement and all those things. Here, the father-in-law and mother-in-law are before your lordship. They say they have no objection. The policy also, the law is that the nominee is only entitled to receive, to hand it over to the person who is entitled to in-law. So in terms of section 8, the mother-in-law and the daughter-in-law will
record their statements that they have no objection.
That's what my friend says.
We can record unless you want them to file an affidavit.
My lord, your lordship may defer it for to some other day. My lord, short date may be fixed so that my friend can file an affidavit. Because he says that this is the development.
For the respondent number 1 and 2.
They will not have any objection because they have to only discuss the amount.
For respondent numbers 1, respondents number 3 and 4, who happen to be the father-in-law and mother-in-law of the present appellant number 1, states on instructions that respondents 3 and 4 do not have any objection to the respondent number 1 LIC making over the entire insured amount to the present appellants. Full stop. He states that an affidavit, a joint affidavit to that effect of respondents 3 and 4 will be filed before the next date. You are for the LIC?
LIC.
All right. List on 12th December?
Mine.
12th December.
I may be pardoned. Possibly the interim order was there. I don't have a noting. If it is there, may kindly be extended. I'm extremely sorry I couldn't take note of it, ma'am.
All right. Interim order to continue.
Deeply obliged, ma'am.
Item number 25.
I may please your lordship. Lord, kindly to make an adjournment for 10 days. We are missing file and our clerk is unwell, my lord.
Who's unwell? Clerk is unwell.
Sure, my lord.
Okay, the clerk of the council of the appellant is stated to be unwell. List on 29th March. So we have now new categories, sir, for adjournment.
Sorry, my lord.
All right.
Item number 26. Item 26.
None appears for the appellant. Dismissed.
Item number 27.
Also, I'm for the appellant. Now, before I start this particular case, this case involves too many complicated facts, my lord. So I feel deficient in presenting all the facts because of my not incomplete preparation.
All right. Counsel for the appellant states that he is not fully prepared to argue the present appeal today and needs some time for that purpose. This was 6th March.
Beg your pardon, my lord.
6th March.
Obliged, my lord.
Item number 28.
May I please lordship item 28, my lord. This writ application is filed challenging the order of the Honorable Single Judge passed in WPC 15235/2019, dated 27/8/2019. My lord, it is related to the promotion from the rank of the forest guard to the forester, my lord. My lord, in the order dated, it was only directed to consider the grievance relating to only the objection. My lord, only for that.
Why interfere this?
My lord,
challenge
my lord, counter has been filed only by respondent number 2 and 3, my lord.
No, but why should we interfere, sir? This is only.
My lord, we will file the rejoinder, my lord. We'll file the rejoinder, my lord, in response to.
So, what is the direction issued? Why are you agreed by the direction?
Lord, Honorable Single Judge disposed of the writ petition only by directing the respondent number 2 to consider the objection filed by the appellant on 29/7/2019 only. Being agreed by such, the impugned order dated passed in WPC, the appellant preferred this writ application, my lord. Writ appeal, my lord.
What's wrong with the impugned order, sir? It's only a remand saying please consider his objection. How can you have a problem with that?
My lord, will take instruction regarding the agenda, my lord.
We'll relieve you of that burden, sir. The present appeal is directed against an order dated 27th August 2019, passed by the learned single judge. disposing of writ petition civil 15235 of 2019 filed by the present appellate with a direction to the opposite parties, public authorities, to dispose of the objection filed by the present appellate with an appropriate order in accordance with law within a period of 2 months. Counsel to the appellant, having used the memorandum of appeal and having heard learned counsel to the appellant, the court is unable to find any ground made out for interference with the impugned order of the learned single judge. Consequently, the court is not inclined to interfere with it. The appeal is dismissed.
Item number 29.
Interim order is vacated.
Item number 29.
And I am permitted to withdraw it, my lord.
29 dismissed is withdrawn.
Item number 30.
None appears dismissed.
Item number 31.
My lord, I'm appearing on the instructions of Senior Advocate D.P. Nanda. The matter is transferred. Kindly delete our name from the process.
Which item, sir?
31.
That's for the respondent, sir.
My lord.
None appears for the petitioner dismissed.
Item 32.
32, my lord, is not pressed. Not pressed dismissed.
Item number 33.
May I please, my lord? I'm sorry, my lord, I'm in this BC, my lord. My lord, here the petitioner initially, as per the advertisement under Annexure 1, your lordship, that is in Odia, I'm sorry, that is for query lease, my lord. At page 11, my lord, that is in Odia. So for participation in the process, my lord, under the rules, the petitioner is to deposit the initial amount, the bid, to participate, the bid amount is to be deposited. The petitioner deposited and succeeded. What happened thereafter? Because of some problems, financial problem in the family, he did not deposit the bid, the total auction amount, my lord. So,
how is this matter still alive, sir?
No, because they have he had executed some work in another organization, and the amount that is with the bid amount that has been deducted and it has been returned back, and simultaneously a certificate proceeding has been initiated against the petitioner. That was the problem. Your lordship, Annexure 2, your lordship may kindly see Annexure 2, the letter of the Tahsildar. I'm sorry, my lord.
What's the amount involved, sir?
32,000.
So please be serious.
Yes, my lord.
You want two judges of a High Court and the High Court to interfere. What is all this, sir? Please. No reason.
32,000 for that man is quite a...
No. Please. You say no sufficient reasons have been made out for recall of the order dated. So the CMAPL.
No, what will have, may be pardon, my lord, 32,000 they have returned back, plus simultaneously certificate proceeding has been instituted. So 64,000 they are going to recover, my lord. Now the certificate proceeding is staying. Pending.
All right.
Item 34.
Lord, the review petition was dismissed in a unfortunate situation, my lord. That when I was in another court, the matter was called, and I could not appear at that time, so therefore it has been dismissed, my lord. And so far as the review petition is concerned, my lord, it is a year-old review, I do admit, my lord.
But only question involved in this case, my lord, that by ignoring a vital document that is Exhibit D by 7, that is Annexure D by 7 annexed to my counter, my lord. This court held that I am not getting the scale of the transgraduate scale from the beginning. So therefore, I am not
ground for appeals and not a ground for review.
Only he will get some retirement benefit, my lord. In the meantime, he has retired.
All right. The same APL, for the reason stated, the application is allowed. The order is recalled and CW or VW is restored to file. Then, sir, you have to pass a separate order in that review petition, correct? In that separate order in the review petition, you say, today the matter has been restored by virtue of the order passed by this court in CM APL 24 of 2015. That's the first line. Second line, no grounds made out for review. The review petition is dismissed. So two separate orders.
Item number 35.
Item 35, may I please, Your Lordship?
Yes.
In case the Mr. Patnaik appearing for railway has filed the writ, which is not continuing in the railway panel in view of the central government notification 2022. So,
My lord, in this, Lord, and DSA allotted this case to me, my lord. But file is not with me. The file is with Mr. Patnaik, my lord.
So you decide, sir.
My lord.
We're not adjourning it for these.
My lord, only one date he will hand over the. I have already.
Sorry, we can pass it over if you need. For a CM APL restoration and all, we are not adjourning. We are in a difficulty. Just like you have so many difficulties, we have this difficulty. We're prepared to pass it over, sir.
For one day, my lord.
No, we'll pass it over, sir. You can come back in an hour or two or whenever you like.
My lord, Miss Patnaik is in his
after lunch.
All right, pass it over, madam. It may be even before lunch, depending on how fast the board moves. We'll just pass it over. All right.
Item 36.
Sir, prayer for adjournment.
For what, sir? What's the reason?
Sir, due to some personal difficulty, Mr. Dwivedi could not appear in this matter.
What is the difficulty?
Sir, actually, he has a child 2 days ago. So,
I see. All right. Counsel for the petitioner stated to be in some personal difficulty today. List on 20. 20th March.
7.
37, may I pray for a Passover, my lord, on behalf of Mr. Kerr?
All right.
Item number 38.
38, my lord, on behalf of Mr. Harishchandran, he has some personal difficulty. Let it be taken next week.
What is the personal difficulty, sir?
Well, some medical problem.
Counsel for the petitioner stated to be unwell. List on 27th March.
Item number 39.
39, mile kindly pass over.
Pass.
Item number 40.
40, Your Lordship, may be disposed of with the liberty to file afresh if cause of action.
No, review petition, sir. Are you appearing the same matter?
Yes, that is.
Item 40 is a review petition.
Yes, sir.
Where's the question of fresh cause of action? You're not aware what the matter is?
Your Lordship, we have actually, our officers actually misplaced the file. That's
Sorry?
Officers actually misplaced the file. Your
You misplace the file, you're just taking a chance by making a submission, not knowing what the matter is. All right, no grounds made out for review. Review petitions. All right.
Item number 41.
Made.
Turn to page 7 is the input order.
So already a delay of 166 days. There's a delay of 166 days, which is not properly explained. So on merits also, the court finds no reason to review the order. And the review petition is dismissed both on the grounds of delay and merits.
Item 42.
Facts remain that we have challenged that order in FO number 68 of 2000.
Then that's fine, sir. Anyway, so.
Item 42.
None appears dismissed.
Item number 43.
Not pressed. 43, my lord, I am for the appellant, my lord.
Yes, please.
My lord, not pressed, my lord.
Sorry?
Not pressed, my lord.
Not pressed. All right. Dismissed is not pressed.
Item 44.
May please, your lordship, not pressed.
Not pressed, dismissed. Okay.
Item number 45.
None appears dismissed.
Item number 46.
May be permitted to withdraw.
Dismiss is withdrawn.
Item number 47.
Item 47, my lord, on behalf of Miss Misra, no instructions.
No instructions dismissed.
Item number 48.
May I please? Lord, there is some, the petitioner had constructed a house beyond the approved plan, for which there was an order of demolition passed by the BDA on 22nd of August 2005. Thereafter, the petitioner made an application. It has been compounded, and the irregular construction has been regularized by the order of the BDA. That is on 11/6/2009. But the opposite part number 1 filed a writ application before this honorable court with an incorrect address, for which the notice could not be served upon the petitioner. And this honorable court directed for a demolition of the house of the petitioner to the extent of the unauthorized portion, which has already been regularized by the order of the BDA. My lord, even the counsel who is appearing for the BDA could not brought to the notice to this honorable court that this unauthorized construction has already been regularized. Your lordship may kindly have a glance to Annexure 1 at page 80 brief, way back on 11/6/2019.
Note what happened. No stay was granted in the review.
No stay, but after filing of the review petition, the BDA authorities have not demolished our structure.
This is due humility, my lords, with due humility. This relates to different branches, regularization by a planning branch and unauthorized construction by other branch. We have taken instruction, they have not appeared, no information. We have taken instruction from UAP authority and we have stated it. But in fact, my lord, that has been regularized. Quite annexed, my lords, that
Mr. Mahapatra, learned counsel appearing for the BDA, states on instructions that the building of the additional construction by the petitioner has in fact been regularized. Paragraph, this fact was not brought to the notice of the court when it passed the order dated 20th November 2013. In that view of the matter, the said order is hereby recalled and reviewed. The review petition is accordingly allowed, and writ petition civil 8374 of 2009 is restored to file. Now, a separate order has to be passed in writ petition civil 8374 of 2009. There will be two orders, sir. One in the review petition, separate order in the writ petition. The writ petition has been restored today by virtue of the order passed today in review petition numbers 26 of 2014. Who's for the original writ petitioner?
Not
list before the roster bench.
It's not appearing, man.
Anyway, when they don't appear, we'll see. On 2nd January 2023.
39.
The delay is condoned at MC 208.
49.
For the reason stated there, delay is condoned. MC 208 of 2014 is allowed.
49.
Item 49, the noting is certified copy of order dated 2/12/2013 in double petition number 9664 of 2013 is not filed, my lord. My lord, I am permitted to file within a week, my lord.
No, sir. We're not inclined to do that, sir. It's a 2014 review petition.
My lord.
It's 8 years old, sir. we're not inclined to grant you time for that. So for the last 8 years, a certified copy of the order and review is not able to be filed by the review petitioner. The review petition is accordingly dismissed for non-prosecution.
Item number 50.
May appearance may kindly.
Item 50.
My lords, no instruction, my lords.
No instructions dismissed.
Item 51.
Not pressed,
Not pressed, dismissed.
Item 52.
I am for the OP number 16 and 17.
None appears to the petition. Dismissed.
Okay.
Item number 53.
None appears dismissed.
Item number 54.
None appears dismissed.
Item number 55.
55, no instruction.
No instructions dismissed.
Item number 56.
May please, your lordship. My lord, the petitioner filed the review petition in the judgment dated 17/11 of 2014, my lord, passed in writ WPC number 1180 of 2014, and further pleased to admit the opposite party to stop the JICA project work in Cuttack City during monsoon season and to cover all holes made by JICA before monsoon every year for public safety, my lord.
How is the issue alive?
My lord.
What is the ground for review?
Well, the ground of negligence, my lord, has to form a contingency fund which shall be 20% of the project cost and regulated by the Honorable Court, which will interview in the damage and on tower indicates cost due to JICA project and negligence of Commissionerate Police, and the commit will keep the check and balance over the JICA project, my lord. And the judgment, my lord, Annex 12, page 56.
What's the ground for review, madam?
Good ground check. The ground that kindly see in the annexer 5 so that was instructed to delay 24-hour security personnel till the project completed and to produce the road issuing permission before commitment to work, my lord.
All right. You said no grounds made out for review. The review petition is dismissed. All right.
Item 57.
None appears dismissed.
Item number 58.
None appears dismissed.
Item number 59.
None appears dismissed.
Item number 60.
The type I order the note prepared by the registry. The IA is allowed as straightforward. The correction be carried out. The earlier order be downloaded and the corrected order be uploaded.
Item 61.
And the impugned order is Annexure 6, page 87. This is passed by the Additional District Judge Salehpur in FAO number 74 of 2013. The confiscation proceeding was entirely quashed on the ground that the search and seizure is illegal, not in consonance with the provisions of the Code of Criminal Procedure. The first time it is coming, fresh admission. Within the limitation period, we have challenged this order. And the learned district judge has held that you have not followed the procedure of CRPC. That is why this our case is that it is a forest offense. And according to the...
What is FAO?
They were doing certain...
What does the FAO stand for?
My lord?
First appeal against
FAO is against first appeal against order.
How is the
Initial order was passed by the forest authority.
How is the writ petition maintainable?
Yes, that earlier also there was a writ petition, it was remanded. After remand, the DFO passed the impugned order that was challenged in appeal. Appeal, it was set aside and then...
No. Against an order in an FAO, how is a writ petition maintainable?
That is against the order of the district judge, the writ petition is maintainable, my lord, because there is no other efficacious remedy, there is no remedy. Because that is the last authority, appellate authority.
No, why is it for a division bench? Is it a DB matter?
Under the Sovereign Act, once the property is confiscated...
Is it a DB matter?
This is coming under Forest.
I'm just asking.
Forest Act.
No, but is it therefore a division bench?
Maybe assignment of, I think it is a single bench assignment.
I think so.
That is right. Also,
the registry will ascertain the correct assignment of this matter and list it accordingly on 5th December. 5th December.
5th. Obliged.
Item number 62.
Your Lordship, my Lord, petitioners are challenging the misappropriation of government funds in the name of providing houses under Pradhan Mantri Awas Yojana.
I think you should go to the Lokayuk, madam. Please go to the Lokayuk for this. You say for the issue raised in the present petition. The petitioners are permitted to approach the Lokayukta in accordance with law. The petition is accordingly disposed of.
Item 63. Item number 63.
It's a new matter.
I'm sorry.
Our designated serious name is being shown. Civil Palan. Not a designated.
So PIL, my lords. NGO with impeccable.
Delete the name. Yes, please.
A PIL has been filed by an NGO with impeccable credentials, my lords. The issue that is sought to be brought to your lordships notice is this: that my lords, all over the state, certain measures have been implemented only in Jajpur district, which to prevent illegal mining, my lords. Rampant.
There are two defects here, sir.
My lords, I have the defects have been removed.
No, I don't think so.
Once I'm passing on the proper neat copy.
No, there are two defects, sir. I think defect number 22 must be that you have not made a representation.
There was no representation before filing. They should have
that is another
the state
defect.
government for this.
Legible copy is only one defect. The other is that representation should be made.
No
So you
representation.
may want to
is
withdraw
also
this to make a representation and then come back to the court.
My lords.
Counsel for the senior counsel of the petitioner seeks leave to withdraw the present petition with liberty to first make a proper representation to the authorities in accordance with law, and after following up on such a representation, to seek appropriate remedies in accordance. This post of is withdrawn with liberty is paid for in the above terms.
Item number 64.
Item number 64. It's a PIL matter praying for immediate treatment for a person who is orphan child who is suffering from epidermolysis bullosa, and her condition is extremely critical. And she needs immediate treatment, your lordship. She cannot eat also, as her condition is extremely critical, your lordship.
Where is she located, sir?
She is in from Jajpur. I have written her present.
Where can she get this treatment?
From SCB. She was referred earlier to SCB. Page number
want to find out?
Page number 24, she was earlier referred to SCB. And they even accepted the fact that she needs amputation. But after that, nothing has happened, Your Lordship. Her condition is extremely critical, Your Lordship. Even I have attached photograph, page number 21.
It is stated that a 12-year-old child residing at Golagaon Panchayat, Dangadi district, Jajpur, who's in a very poor financial condition, is suffering from a rare medical disorder known as epidermolysis bullosa, which results in easy blistering of the skin and mucous membrane and needs immediate medical attention. Paragraph. Added to the misery is that the child is an orphan and is at the mercy of her neighbors who are providing her with food. She is unable to get immediate medical treatment at the nearest available medical facility, that is the district health hospital at Jajpur. In the circumstances, as an interim measure, it is directed at the present petitioner, Mantu Das, will accompany the said child and appear before the superintendent of the SCV Medical College and Hospital. When earliest can you go? Tomorrow, day after?
Day after tomorrow, Your Lordship.
On 24th November 2022 at 11 a.m. And the superintendent will arrange to have a complete medical checkup with specific attention to her peculiar problem and arrange for her immediate care and treatment. A report of compliance be filed before this court by the next date. List on 30th November.
Deeply obliged. Your Lordship, I pray for urgent certified copy.
Certified copy. The Registrar General of this court will communicate this order forthwith to the superintendent of the SCP Medical College. Telephonically and by email.
I'll also communicate. Item 65.
Deeply obliged.
My plea, Your Lordship. But the petitioner challenges the order under Annexure 1, that is the attachment order issued under Section 79(1)(c) of the OGST and CGST Act. That is page, running page 7, my lord, on dated 22/8/2022, my lord. Well, here the allegation is that at paragraph 4, my lord.
The defects. This all font is not correct at all. Just open the petition. Let's see the font. Not as per our filing guidelines.
But I have filed the appeal, my lord. When the appeal is pending, they have issued the order of attachment, my lord. Appeal final order is pending, my lord. That is violating the section.
You have not filed it in the format which is prescribed by this High Court.
Format, my lord.
Yes, defect is there. Defect has been pointed out.
Defect is regarding the capital letter of the.
No. Entire petition is defective. Not in accordance with the High Court rules, which has been put in place.
That's it.
There's a miscase order may be given, my lord, by lifting the attachment on my bank account, my lord. I am not.
Cure the defect, sir. How long will you take to cure the defect?
Well, I shall remove the defect, my lord.
How long will you take to do that, sir?
Only this week I shall remove the defect, my lord.
Counsel for the petitioner undertakes to remove the defect within 3 days, list thereafter.
Item number 66. Notice under section 125 I have challenged. 148.
What's this defect?
The copy I have already served.
It's served. All right.
So, assessment year 13-14 barred by limitation.
Covered. In the challenge in the present petition is to how come they everything might change for the last more than 1 hour? By the time orders reach me, it will be midnight.
Page 16.
30th March 2021. Under section 148 of Income Tax Act 1961 for the assessment year 2013-14. In view of the order dated 24 January 2022, in writ petition civil 20919 of 2021 and batch bracket Messrs. Ambika Iron and Steel Private Limited versus Principal Commissioner of Income Tax. And the order of the Supreme Court of Union of India versus Ashish Agarwal, Supra. The impugn notice and all proceedings consequent thereto and orders consequent thereto are hereby quashed. The writ petition is disposed of.
Order has been passed. Here the order has been passed.
And orders consequent thereto.
Yes.
Item number 67.
67 kindly pass.
All right, pass over.
Item number 68.
68 and 69 will pray for an adjournment. It's not today, some other day.
All right. At the request of counsel for the petition list on 27th March.
Item 69.
69, same order.
Same order.
Item number 70.
No, 67, what happened? Pass over.
It's an application where an advocate of this honorable court was illegally detained, arrested for 2 years, 3 months, 5 days. And ultimately she came out without any evidence. She was honorable and she claimed compensation.
You're ready with the matter, Mr. Manthi?
Yes, my lord.
We'll take it at the end of the board.
My lord, this may be.
We'll take it at the end of the board, sir.
My lord, petitioner is to file rejoinder. Have you filed the rejoinder?
No, rejoinder is specific direction was given to give reply.
On the last date, he prayed for file rejoinder by the next day. I think he has not filed any rejoinder. No. Can I see the last date's order?
Yeah, last order says rejoinder.
Yes.
Pray for little more time to file rejoinder.
That's
all right. Counsel, the petitioner prays for and is granted further time to file rejoinder by the next date.
And since the other opposite parties have already appeared, noting is that the notice is not sufficient. All of them have appeared. Common counter has been filed for all the opposite parties.
All right.
It may be ignored.
Yeah. It is seen that a common counter affidavit has already been filed on behalf of all the opposite parties who have all been served. All right.
For land for Star Hotel, which after completing all the proceeding, you will also kindly see his application, which required fee of 20,000, was considered under Annexure 5. Annexure 5, page 16. Last paragraph, you will also kindly see.
So
the general manager DIC.
Opposite parties 3 and 5 have not been served.
My lord?
The private opposite parties have not been served. No, 3 and 5. District Industry Director of Estate. No, I can.
And his application was recommended to the GA department. And your lordship kindly turn to the GA department site selection proceeding under Annexure 6, page
Lordship may.
page 23. Your lordship kindly see page 23 in serial number 13. Allotment of land in favor of Mrs. DN Infrastructure and Hotel for establishment of a star hotel. Proprietor Mrs. DN Infrastructure and Hotel has requested for allotment of land, preferably in Joydev Vihar and
series of representations
for establishment.
My lord, or else your lordship may direct with a specific direction to obtain instruction. What is the status of the recommendation? There is a recommendation as he is showing in page 23.
23 as well as annexure.
But this is of the year
specific affidavit be filed by the opposite party state, informing the court the status of the recommendation made.
Annexure 7, my lord, that is also site selection committee has allotted already 2 acres of land at the Joydev Vihar.
Site
No, that is a recommendation.
And that is another site selection committee. Your lordship 33, page 33, your lordship kindly see.
The affidavit be
Page
filed
33,
at least 1 week prior to the next date.
serial number 30.
My lord, director of estate may be directed to file.
The affidavit be filed by the director of estates at least 1 week prior to the next date, with an advance copy to counsel the petitioner. It is permitted to file a reply that if any before the
Annexure
next
9
date,
series is pending before him.
less than 6th March.
Item 72.
None appears for the review petition.
Item number 73.
Lordship can give the time limit so that they will dispose.
My lord, item number 72, no instruction.
72, no instructions dismissed.
Item 70.
To continue, my lord, 71.
There's no interim order.
There was the interim order also.
It's only subject to, it will be subject to the outcome.
That is
That's not
subject to, that is.
Because they will be allotted or to any other person.
Let's read the interim order, sir.
Yes.
Kindly read the interim order.
Yes.
What does it say?
Result of this case, my lord.
How can that be continued?
That
Item number 73.
Wait, please, Your Lordship. Item 73, the order has been complied, my lord.
All right.
Hence, not press.
Dismissed is not pressed. All right.
Grateful.
Item number 74.
74, Your Lordships. I'm forwarding a date chart and a small note, Your Lordships. This review which is being filed in pursuance of the Supreme Court order. But Your Lordships, before I place the case, may I just take through really what the recruitment process was all about?
All right.
Your Lordships, actually, this is for a gangman and the Group D post. So we have to first apply and form an application where you do put your photographs. Then you're called for a physical test, which is only a call letter. So you reach the venue along with 2 photographs. There the invigilator looks at you, looks at the photograph of the application form and the 2 photos that you got and asks you to put 1 photograph in the admit card of that physical test and in the admit card of the written test, which will be held later if you succeed in the physical test. And in front of the invigilator, I'm supposed to sign the attendance sheet as well as the admit card meant for physical examination. I take it, I'm successful, I'm called for the written exam. When I reach for my written exam also, again, the admit card, which has that prefixed photograph, which I had fixed it in the date in the venue of the physical test, is compared with, I'm allowed to sit in the exam. And I sign in front of the invigilator. Then, Your Lordships, I'm actually selected. The viva doesn't happen. A verification happens. In the verification, nothing is told to me. I make a query as to why am I not, what is the result of the verification. After 1.5 years, what they say is at page 3 of that date chart. I'll show it from the records.
Your Lordship, I am for OP, Your Lordship, seeking adjournment, Your Lordship, for instruction.
This is a very old review petition, madam, 2014.
Your Lordships, they have filed additional counter after the Supreme Court directed for a review. Your Lordships will see page 3 of my note. First, they say that the photograph on the admit card for the physical test don't match with the appearance of the person on the verification date. And the signature of the person on the admit card of the physical test don't match with the signature on the verification sheet. I file an OA. The tribunal directs me to be appointed. However, the matter
Can you show me the order of the Supreme Court?
Lordship, is the last annexure of the review application, which is at page 81. Page 81, annexure 19. Basically, Your Lordship, the High Court had dismissed the application on the ground.
Where is the 30th August? Oh, I see. On the short ground. I think we'll just put it before the regular DB.
Lordship.
This review petition has been filed pursuant to the leave granted by the Supreme Court of India by its order dated 4th April 2014 in SLP Civil CC 4930 of 2014 against the order dated 30th August 2012 passed by this in petition civil 16754 of 2010. To stop the said order, the Supreme Court of India reads as under. Take from page 81. Paragraph. Although the present review petition counter affidavit, rejoint affidavit, and a reply to the said rejoinder has also been filed. The fact remains that the order dated 30th August 2012 does not spell out the reasons for dismissal of the writ petition. On that short ground, the order dated 30th August 2012 is hereby reviewed and writ petition civil 16754 of 2010 is restored to the file of the division bench. Paragraph. The counter and rejoinder filed in the present review petition will be placed on the record of the said writ petition and can be relied upon by the parties in the said writ petition, which has been restored to file. Full stop. Then in the second order, which is in the writ petition civil 16754 of 2010, the present writ petition has been restored pursuant to an order passed today in review 66 of 2014, paragraph. As directed in this order, the counter, rejoinder, and reply to the counter affidavit filed in review petition 66 of 2014 will form part of the record of the present writ petition and is permitted to be relied upon by the parties. List before the roster bench on 12th December.
Obliged.
All right.
Item 75.
In item 75, Your Lordship, the government has just submitted a copy of counter affidavit. The matter at hand is, Your Lordship, the present petitioners, they were working as the Urdu teacher in a Urdu school. Now, subsequently, under Annexure 1 in 1979, they have decided to give them the revised scale of pay under 1983 and 89 rules. Now, accordingly, our scale was enhanced. Now, Master, may kindly see Annexure 9 at page 26. In the year 2005, now they have decided to recover such amount which has been given to us from 1982, Your Lordship. That is at Annexure 10, Your Lordship.
Yeah, just read it.
Yes, Your Lordship. The state in its School and Mass Education Department calls in question the common judgment dated 6/2010 passed by the learned Odisha Administrative Tribunal in 4 original applications. By the said order, the learned tribunal finding that immediately no show cause notice was issued to the applicants taking any steps to recover the amount wrongly paid to them, has quashed the said order of recovery and has allowed the original applications.
These were original applications filed by you?
Yes, Your Lordship. Now,
No, just read on.
Yes, Your Lordship. We do not find any reason to interfere with the state order of the learned tribunal. But however, in the event the state decides to take any action for recovery of the alleged amount paid to the applicants in the original applications, the applicant shall be given opportunity of hearing before implementing the decision by the state. Now, my case is, Your Lordship, such an order has been passed without referring to the order passed by the original Odisha Administrative Tribunal. My Lordship, they have stated that such an order has been passed for increment of our pay scale pursuant to the resolution of the government itself. Now, what they have done is, in 2005, they have implemented a new guideline and they reduced our pay scale. And on the basis of that, they're trying to recover our pay scale from 1982, Your Lordship.
But you'll only be given notice. All that has been said, nobody's on the validity of such recovery. Only a procedure. In fact, that is the order passed by the tribunal quashing all the recovery orders has not been interfered with by the court. They've said in future, if you again seek to recover, you'll issue show cause notice. So what's wrong with that order?
Actually, my Lordship, I have got an instruction from my client that pursuant to 2005, they have reduced their pay scale and they are giving them the pay benefit.
That's a separate cause of action.
Yes, the liberty, I will approve this court.
That's all right.
Yes,
Consequently, the petitioner seeks leave to withdraw this review petition with liberty to pursue the other litigation already instituted by the petitioners in accordance with law. Dismissed is withdrawn with liberty spread.
Actually, I'll even say disposed of. Otherwise,
disposed of is withdrawn with liberty. All right.
76 also same.
Same.
I'm grateful, Your Lordship.
All right.
Item number 77.
Item 77 is infraction.
Infraction is dismissed.
Item number 78.
My Lord has directed Municipal Corporation BMC to file a complaint.
BMC was supposed to file
The
that.
BMC, we have received the Paravise reply, my lords, will be filing our counter. But in fact, my lords, BMC has limited role. The main contesting parties R&B department, who is constructing the drain, and the sewerage line is developed by Odisha Water Sub Sewerage Board.
You file your affidavit anyway, sir.
My lords may grant some further time, we will file it.
My Lord, in this case, OPL filed their counter on 12 July 2022. While in para 6, they have stated that BMC is to take up the work.
An affidavit.
And my lords, a complete set of read petition may be served, my lords. Alternate pages are missing, my lords, in the read petition.
See, you don't have to wait till today to ask for that, sir. This order was passed on 10th August. You wait for 3 months and now tell us that 2 pages are missing.
My lords, we have received Paravise, we will be filing also.
Counsel appearing for the BMC seeks and is granted 4 more weeks to file a reply. The reply will specifically deal with the averments made in the counter affidavits filed by opposite parties 4, 5, and 6 and opposite party number 1, as well as opposite party number 9. If those affidavits have not already been served on counsel appearing for the BMC, it should be furnished forthwith. Stop. Additionally, counsel BMC is permitted to collect a complete soft copy of the complete paperwork from the court master on producing a pen drive. That's the easiest way for you to go about things.
Yes, madam.
PI list.
Sir, 17.
No. 11 January.
Item 79.
79, my lord, last date I appeared for Barampur Municipal Corporation, my lord.
May please your lordship.
79 is.
I am filing it.
This is not in 79.
79, my lord. On the last date, I appeared for Barampur Municipal Corporation, my lord. And I am filing a very too small affidavit, my lord, with a prayer that your lordship may give me 3 weeks time at least to file a detailed affidavit, my lord.
No, same matter. It's the same matter. This is the third matter. Give me that note. Council appearing for the Barampur Municipal Corporation seeks and is granted 4 more weeks to file a reply. File an affidavit.
Today I am filing
Pursuant to the order dated 8th April 2022.
May
What is he filing? What have you filed, sir?
Small affidavit relating to the wastewater management as on existing today, my lord. So I will file a plan of treating with all effluents.
All right, you take that off. You say council appearing for the BMC is handed over in court. A short affidavit. Stating that there are 2 sewage treatment plants which are already in operation, and another at Sitallapalli with a capacity of 60 KLD will be operational by the end of this month. He undertakes to file a further affidavit, placing on record the comprehensive plan for dealing with pollution in the rivers flowing past area. The said affidavit filed within 4 weeks. What about the others?
May I pray, my lord? I am the petitioner in this case, in case of Maitri sir. This is a PIL, my lord, and petitioner filed this writ application, and this matter appears today's list as per order number 42 dated 10 October 2022. Earlier to this order, this honorable court passed an order in order number 41 dated 6 September 2022. I would like to place this said order if your lordship permits, my lord. Place this on 10 October 2012 along with WPC number 2746 of 2000. In meanwhile, the petitioner is permitted to file an affidavit with an advance copy to Mr. Naik, London Council for the CMC. In obedience to the said order and direction, petitioner has already filed an affidavit, my lord, which is dated 22nd September, and the same finds place at flag 35, my lord. I would like to draw your lordship kind attention to the said affidavit, my lord. Affidavit dated 22nd September, my lord, which is at flag 35 of your lordship brief.
Yes.
I would like to draw your lordship kind attention to annexure 2 at page 8. That is the English translation of the news item dated 9 August 2022. I would like to read this said English translation if your lordship.
Not necessary, sir.
My lord.
Not the entire thing, please.
My lord.
Basically, you're saying women have to climb 25 feet to fetch some water.
My lord. That thereafter, I would like to draw your lordship kind attention to annexure 4, my lord, at page 10. That is also English translation, wherein it has been reported that
24-hour water supply
is not enough, my lord.
All right.
Thereafter, I would like to draw your lordship kind attention the important document that is annexure 6 at page 32, my lord.
Yes.
That is the urban Odisha using unsafe drinking water.
All right. Let's ask the CMC.
My lord. Let them.
CMC.
There is no response. We have not filed any.
State is already undertaking a project.
No, all that is fine. How are you doing daily? These are the daily problems faced by persons. This undertaking a project and all is one long-term measure. Nothing happens on the ground. People are every day. People, if they have to climb 25 feet to just get drinking water, There's something seriously wrong.
Well, let me just take
And this is Cuttack city. We are not even looking at some. This is our own. The city where the High Court is.
I just take specific instructions and then come back to my lords.
CAG report, my lord, very clear.
An additional affidavit in the first matter, you say in writ petition civil 16562 of 2016.
My lord.
And an affidavit has been filed by the petitioner on 6th September 2022, inter alia, highlighting the news items regarding women in the Mangalpur village of Jatra Panchayat under the Banshapala block in Cuttack district.
My lord, that is Keonjhar, sir.
Sorry?
That is my lord Keonjhar.
That's Keonjhar.
Then what are you? I thought you was talking of
no, Cuttack Annexure 4, Cuttack Annexure 4, my lord.
So, which issue was you highlighting?
And entire state, my lord. I have filed this read application for the state, my lord. Not confined to Cuttack, my lord.
Mr. Amar, you are confining to Cuttack.
No, entire state.
Then that will become unmanageable, sir.
Cuttack city also, they are not getting drinking water twice a day, my lord. Annexure 4 at page 10, my lord. Annexure 4, page 10.
Okay, you say inter alia, highlighting the non-availability of drinking water. In Cuttack city. Bracket annexure 4 to the affidavit. Stop. He is also highlighted a news item quoting the report of the Comptroller and Auditor General, bracket CAG, bracket, tabled before the State Assembly. So what is the date of this news item?
This is, my lord, 24/8/2022. And the claim is that the project is for 24 hours water supply. So that is the project that my lord was referring to that state government has taken up for implementation. It's currently now under implementation. So if the government files, the department Watco files an affidavit, then that should be clear. Because they have a clear timeline as to when this will be implemented. It's already underway.
Underway is one best word, sir, which can hide everything.
No, my lord, there's an affidavit filed to the effect by the state giving phases. My lords would probably not recollecting that. Next date, I think I'll place that affidavit. The state should also place that affidavit.
CAG report, my lord, very clear. Annexure 6, page 32. Urban Odisha using unsafe drinking water. The last paragraph of the CAG report says, my lord, CAG found 9 labs
highlighting the shortage
by
of
public
water treatment plants as well as water testing laboratories.
My lord.
Full stop. For the number of hand pump tube wells were found to have not been tested. And only 10 out of 19 divisions were covered in the testing. The CAG has further found the 9 labs set up by the Public Health Engineering Organization in collaboration with Spectro Analytical Lab Limited, at the cost of rupees 18 crores, not conducting 4 important tests of disinfection byproduct, bracket DBP, and ionic detergent, chloramine and mineral paragraph. Mr. Devishesh Nayak, learned counsel appearing for the Cuttack Municipal Corporation, states that an affidavit will be filed by the CMC, specifically dealing with both the above aspects. before the next date. What about the other municipal corporations?
My lord, Watco should also be made a party and
They have already been made a party, sir.
my lord, that Watco is the appropriate body because they are the ones undertaking the entire.
CMC as well as Watco, you said, will file separate affidavits dealing with the above aspects. Tenth January.
Oblige mail.
Item number 80.
I am for the petitioners in this case. Office directed Panchayat Raj Secretary to file his affidavit.
Padmalochan Baria.
Where is this affidavit, Mr. Manti?
My lord.
Commissioner cum Secretary, Panchayati Raj Department was to file.
Yes, my lord, that is the last chance.
It is seen that despite the order dated 24th September 2022, no affidavit has yet been filed in terms thereof by the Commissioner cum Secretary, Panchayati Raj Department. Last opportunity is granted to do so on or before 2nd January 2023, failing which the said official will remain present in virtual mode before the court, virtual mode next date of hearing. List on 12th January.
Item number 81.
I plead your lordship. Lordship, it's a public interest litigation where the petitioner have challenged the impugned order dated 28/2020 at Annexed 6, wherein the OP number 2, the collector Sundargarh, in not recording the water reservoir in the name of the state government, the state of Odisha, pursuant to the amended provision under section 5B of the Odisha Territories Village Offices Abolition Amendment Act 1976. Before placing the impugned order, your lordship may, I will take your lordships at Annex 2, the act itself. Lordship, it's a Bhugra land. What is the lordship at page 26? Your lordship may kindly have a glance to page 26, section 2B, Bhugra land. Bhugra land in relation, your lordship, page 26. Bhugra lands in relation to any village office means lands by whatever name described or locally known, whether or not recorded as such, settlement papers held as emoluments in respect of such office. Your lordship, kind of a glance through next page.
We'll take it at the end of the board. This will take some time, I think.
Yes, your lordship, will take.
Take it at the end of the board.
Item number 82.
May I request your lordship to take it in another date because I have to come in any short date.
All right, 81, you say Mr. D.K. Mantil, under National Government Advocate, states that he is in some difficulty today for the final hearing of the present petition. Add his request list on 18 January.
18th January.
No, 1 minute. 2nd February.
2nd February. Oblige.
81 matter is 2nd February.
Yes, this.
Item 82.
But here, this PIL matter to provide the shelter that your lordship has directed to file a inquiry report at last order 6922. I
No,
think
we have
it has
filed
not-
our counter affidavit, detailed counter affidavit.
No. That complaints to that to file a report to the honorable court. The inquiry, individual grievances considering. That order is after filing of the counter that 6922 order.
That is the order dated?
19/4 and thereafter 692. You also submitted to comply that answer.
I think there is no such order.
6/9/22, sir.
6/9.
The compliance reports in terms of the order dated 6/9/2022 be filed positively on or before 2nd January 2023. List on 9th February.
Obliged.
All right.
Item number 83.
My lord, on behalf of Mr. Shivshankar Mahanti, I pray for 1 week time, my lord. I have sought one copy to the state of rejoinder affidavit and now serving a copy to the Union of India.
Let them serve the copy of the rejoinder. They have to file rejoinder.
Yes, my lord, I'm now serving.
The rejoinder affidavit of the petitioner has been served today on counsel for the state as well as Union of India. List on 22nd February.
Along with Mr. Raiguru is appearing in the Lakshmi reflected.
Item 84. '84.
May I please? Pray for some time to file rejoinder. I am for the petitioner.
All right. Rejoinder be filed for the next day.
In this second case, I am appearing for the petitioner. They have not filed the counter affidavit in that case.
All right.
Same case, same prayer.
All right. Meanwhile, in 16545/2022, in the first matter, you say rejoinder be filed for the next date. List on 28th February. Sorry, 27th February. And then 16545, you say reply be filed within 4 weeks, rejoinder for the next date. It's on the same date.
Item number 85.
So item 85 in this batch of writ petitions, Lords, I am appearing in the first matter, 6629/2013 and 25046 of 3150 and 3150 of 2018 Lords. Plus 2506 of 2014 counter has been received and I am today filing rejoinder. I am serving a copy on a run frame Lords. And 6629, this will be filed this week, Lords. And so far as this matter is concerned, Lords, the entire challenge is constitutional validity of section 21 of the Orissa Value Tax Act. That's one matter. This Honorable Court has disposed of the Alco's matter that touches the very issue, but the notification which is under challenge in the present application not referred to that. And state has filed SLP that is pending there.
Your Lordship, let me
Yes, I am submitting it. I'm there. So that matter is pending for the Honorable Apex Court because that only related to whether in respect of coal input tax credit is available to the petitioner or not. This Honorable Court has replied in favor of the petitioner and the state has gone there. Cabinet was filed. So now, Lords, this prior to this notification, twice this Honorable Court notification was there to seeking to levy Lords, not to allow input tax credit in respect of coal and furnace oil. In Reliance case, your Lordship quashed. Subsequently, another notification came that your Lordship dealt in case of visa skills. Again, the present notification, they said that there is possibility of misuse by some of the dealers. So therefore, we have brought this law. So I will be filing some compilation of judgments along with the production flow chart and also rejoinder so that your Lordship may kindly fix a date so that matter will dispose of.
Your Lordship,
My Lord, the SLP which is pending before the Honorable Supreme Court against this 1597 that judgment had passed in Nalco matter itself, that is coming up on 10th of January. 38103 SLP civil number 38103 and 38104 2012. 13. That is come in my matter also. They have not filed any counter so far. So let it be listed after 10th of January so that we are.
But in Nalco, this notification has not been dealt in by this Honorable Court.
No, that is pre-amendment. Nalco judgment, Your Lordship, let me clarify the issue.
in NALCO judgment, that has been decided prior to amendment. Subsequently, in 2012, one amendment has been made. Your Lordship, pursuant to the judgment, Your Lordship, earlier a notification has been issued. That notification has been quashed in case of Disa Steel. After quashing of that notification, an amendment has been come. And against that amendment has been challenged in all these batch of writ petition, Your Lordship. Your Lordship, prior to amendment, this has been decided that the coal and furnace oil are raw material, are input in order to avail the input tax credit in case of NALCO. Against that NALCO, Your Lordship might have remembered that has two aspects, one penalty, another is quantum. So quantum, department was there, and penalty, so far as the penalty, Your Lordship has already reviewed, passed the review order. Due to pendency of the review petition here, Honorable Supreme Court could not dispose of the matter, and Honorable Supreme Court has directed to dispose of that review petition, Your Lordship. So in the meantime, that review petition has been disposed of. Your Lordship, even though that is prior to amendment, but ultimately, Your Lordship, that judgment, Your Lordship will touch that judgment definitely. For that reason, in order to judicial propriety, what I request, Your Lordship, all these batch of writ petition may be sanitized, Your Lordship, till disposal of that SLP in case of NALCO.
Yes. The principle of law which is to be decided by the Honorable Supreme Court will definitely have a direct
all
bearing.
parties agree that the outcome of the specially petition filed by the state of Orissa in the Supreme Court of India
381
against the judgment of this court in
38103 and 38104 of 2000.
no, judgment dated. Give us a copy of the judgments.
Your Lordship. So far as the NALCO judgment of this High Court.
NALCO is SL civil number 020670 and 020671 of 2013, registered on 9/12/2013.
The 38103, 38104 of 2013.
38104 of 2013, registered on 9/12/2013.
Yes, 103 and 104.
Judgment dated 9th October 2012 of this court. In NALCO versus Deputy Commissioner of Commercial Taxes. Bracket writ petition civil 1597 and 1686 of 2012. Bracket will have a bearing on the present cases.
My lords, in sub-item
Your
number
Lordship.
3, in the case of NALCO,
They have not filed any counter.
So far as the question of law is concerned, that is Your Lordship, some factual differences are there. Your Lordship, that at the
But
time of
fact remains, my lord. The
that-
notification
at the
which
time
your
of
lordship
argument time.
will now consider in this application, which is impugned bills, that is not subject matter of
factual aspects are
petition
also
filed, so SLP filed with the Supreme Court bills.
All right.
That has no bearing.
Easy. Adjourned. These writ petitions are accordingly adjourned sine die, awaiting the outcome of the aforementioned case in the Supreme Court of India. Liberty is granted to the parties to mention for listing after the judgment of the Supreme Court of India. In the meanwhile, pleadings be completed in all these writ petitions. All right.
Interim orders are there, those.
Interim order will continue.
Fine. So
Wherever interim orders have been passed, they will continue.
My lords, in sub-item 3, in the case of NALCO, the name of the fresh counsel may kindly be reflected in the.
All right. Name of the fresh counsel. Who is the counsel, sir? Name of Mr. Kedarnath Tripathi, advocate, be reflected for NALCO. In writ petition civil 25046.
No, 2506 my case, my lord.
22397. All right. Of 2012. All right.
Item 86.
May I please be asked? The challenge of this petition, my lord, is to the 148 notice and the subsequent proceedings on the ground that this particular notice at annexure 1 at page 16 issued on 31/3/2021, even though it is shown I've received it on 1/4/2021 after the new act has commenced. And I have specifically stated at page 13, paragraph 5.9 of my writ application, page 13, if your lordship would kindly turn, that the Finance Act, lordship court?
Yes.
That the Finance Act 2021 substituted the procedure for reassessment in bringing a procedural one will apply retrospectively, and therefore the notices issued on 31/3/2021 and served on or after 1/4/2021 for the assessment year 16/17 will also be exercised in the prescribed manner under the Finance Act of 2021. My learned friend has filed a counter, my lord. If your lordship would kindly turn to page 7, paragraph 12 of the counter. Now they admit. Lordship got it?
Yes. Yes, please.
Paragraph 12, Lord, that in reply to paragraph 5.7 to 5.9, 5.9, where I've stated that the writ application, it is humbly submitted that as per the Honorable Supreme Court's order dated 4/5/2022, notice under 148 issued to the SSC for the assessment of 16/17 on 31/3/21 was actually delivered on 1/4/2022 as per the data available
must be
on
22,
the system.
31/3/22.
And they say, Lord, a 148AB proceeding has been initiated and they annex it as A1 at page 10, my lords. And pursuant thereto, my lord, I have also filed my reply, my lords. They have not perhaps proceeded because of the interim order, my lords. My humble submission would be, my lord, your lordship may quash this 148 in the subsequent proceeding in the writ application and let them proceed with this 148AB, my lords.
Yes, sir. In view of the reply, in view of averment in para 12 of the reply with the department, it is plain that the impugn notice dated 31st March 2021 issued under section 148 of the Income Tax Act 1961 to the petitioner SSC for assessment year 2016-17 was actually delivered only on 1st April 2021. Stop. Perhaps on account of this, a separate show cause notice appears to have been issued.
This annex AB1 at page 10, notes.
My counter.
Of the counter affidavit notes.
On 1st April 2022, 1st June 2022, yes, for the same AY 2016-17, under section 148, capital A, bracket small b of the Act. In that view of the matter.
And pursuant that you have already filed my objection.
Yeah, it is the Mr. Karar, learned counsel appearing for the petitioner, informs the court that the petitioner has already filed a reply to the subsequent notice dated 1st June 2022.
That is running page 15 of my count.
They have already annexed it.
In that view of the matter, the impugn notice dated 31st March 2021 and all proceedings consequent thereto hereby quashed.
Annex 1 and 3 minutes.
All proceedings and notice consequent thereto are hereby quashed. All right.
Your Lordship, only is the 148 notice earlier, Lord. Because return these
I've said 31/3/2021 and all notices consequent thereto. Okay, 2031 and the notice dated 2nd February 2022 are hereby quashed. All right. The writ petition is disposed of with the above terms.
Obliged.
Item number 87.
Yes. Your Lordships, identical matters have been posted to 25th of January.
Okay.
So this matter may be listed on that day and interim order to continue.
All right. List on 25th January 2023, interim order to continue.
May I pray? I have got 3 matters in the STRB in the weekly list, 45, 69 and 95. Due to my throat, and because of the tomorrow battle of Stalingrad, my lords, so I have to take care of my throat. And 3 snipers are there. So, no, tomorrow. Next week it may be on board.
It will be on board. Sir. Just note the numbers.
Much obliged.
All right.
My lord, I am appearing 45, 69 and 95.
Item 88.
In item 88, I have received the counter just 1 hour back, my lord. Within time to be given.
All right. Result to be filed for the next date. Interim order to continue. List on. 27 February.
Item number 89.
May please.
My lord, some hearing for the central GST in this matter, my lords. My lords, I'm praying for 2 weeks' time for filing of the counter affidavit.
My learned friend is appearing for a person who is not a party before your lordship.
My lord, that's a wrong noting. That is the wrong noting. I'm appearing for respondent numbers 3, 4, and 5. That is central GST. This is a noting that the party is not been added as a party. I'm appearing for central GST, my lords. They have been added as respondents 3, 4, and 5, my lords.
You say Mr. Prashanjit Mahapatra is appearing for opposite parties 3, 4, and 5. He prays and is granted 4 weeks' time to file a reply.
Interim
rejoinder, if any, be filed for the next date. Interim order to continue. List on the same date, 27 February.
27 February.
Item number 90.
Grateful, my lords.
Item 90, my lord, your lordship last occasion directed to file further counter affidavit to state. They have not filed yet, my lord. If they have not filed,
I am for the opposite party corporation, my lord. So your lordship may give at least 2 weeks time to file counter affidavit. Both 90 and 91.
It is a fact that the state was directed to file counter, but if your lordship will look to the subject matter of the case, it is a demand notice issued by the district office. And then demand notice can be examined by the appellate authority. Whatever ground you are taking here, you can.
Your lordship,
that is an
this matter and issue notice, my lord.
And that is correct. I don't.
They have not complied the High Court's orders, honorable High Court's orders earlier passed. Thereafter, your lordship issued notice. Now they have
your lordship because these things is open for them to hesitate before the appellate authority. In all it is a fact that the other court has issued notice. It was listed before.
Your lordship has issued notice, my lord.
It's all right, sir. If there's an appeal provided, why don't you avail this?
Yes, my lord. Appeal is admittedly provided.
My lord, kindly grant time to file rejoinder, my lord, to the present.
You answer
already
the question, sir.
file, my lord.
No,
Why when you have to file it?
Let it be examined by the appellate authority.
The appellate authority, my lord.
These are not matters of counter rejoinder and also. You say admittedly against the impugned demand notice dated 29th July
my lord,
2021.
Earlier order passed by this honorable court.
Correct, so we are aware of that.
29/7/2020.
Against the demand notice dated 29th
My lord, may I request, my lord, one thing, my lord? My lord, kindly be taken up tomorrow, my lord. My senior will
pass it.
This order, my lord, will be passed in presence of my senior.
Kindly request him to remain present, sir. We'll pass it over. All right.
Pass over this last, I think.
It's all right, sir. We're going to be sitting up for that.
He is out of station today, my lord.
Then let the good order be passed today. It's all right.
No way prejudice.
Admittedly against the impugned demand notice dated
1.
29 July 2021 of the Superintendent of Excise Badrak. An appeal is provided under the Section 6, is it?
Yes, ma'am. No, 252.
Section 252 of the Orissa Excise Act, permitting the petitioner to avail of such remedy. The present petition is disposed of if the appeal is filed not later than 2nd January 2023, accompanied by an application for condonation of delay explaining the delay on account of the pendency of the present petition. It will be considered on its merits by the appellate authority.
Your lordship, I observe that it is open for the petitioner to raise all questions.
Yeah. All points urged in the present petition are permitted to be raised by the petitioner before the appellate authority in accordance with law. The court clarifies it has not expressed any in the matter. The petition is disposed of in the above matters.
Item 90, both item and
Same.
91 also.
Same.
The next one is same.
91 also same, is it?
91
same.
Same.
Supplementary cast over matter. Item number 4. Item number 4.
I am appellant in one appeal and my friend is appellant in another. I think appeal is there.
Yes.
Lord, before I submit just in the fact of this case in North Cell is, my lord.
Yes.
The services of the opposite part number 4, I am for the management. The services of the opposite part number 4, my friend's client, was terminated after following the due process of law by serving a charge sheet. Thereafter, she received and given a reply, terminated, because at the relevant time it was an unaided, recognized private institution. So, against that, my lord, there is a provision to file an appeal to the Director of Secondary Education. So he filed Instead of filing appeal, he gone to the inspector of school, who has no authority in the matter. That is the judgment of our own High Court. However, he filed another petition before this honorable court. Falsely stating, I will say, my lord, let us say he has stated that my appeal is pending with the director. Let the director hear it. So this honorable court in the division bench directed the particular representation, what he said that appeal in that particular case is to be decided. But before the director, instead of that appeal, because there was an allegation against some person, he was not made a party, he filed another consolidated appeal. He says that that is gone. This is my amended appeal. Be that as it may, that was disposed of in his favor, directing reinstatement. Against that, because we are not given an opportunity of being heard, so he came before this honorable court in a writ petition. This writ petition, because our allegation was he didn't possess the requisite qualification, training qualification, which is the basic requirement of law, and he was also a registered contractor, C-class contractor under the state, and other allegations, my lord, unauthorized absence, all these things. 5 charges were there. So when I came to this honorable court, again, after hearing the parties, remitted the matter to the director for de novo, a fresh hearing. And the director passed a reason order, holding that he has no training qualification, therefore termination is good. And because a teacher should not have any contractor, he cannot, because the rule provides that one should not have any business, trade, or any employment. So he upheld the order of termination. Against that, he came to the writ petition. And the writ petition was allowed by this single judge, which is impugned before my lord, on the premises, in the statute, there is no provision of training qualification. So, on-trained can be appointed without looking into the statute, my lord. This is the first. And so, but accordingly, he said that termination is bad. It was set aside. However, he has remitted the matter to the director on the point, again, whether this contractor license is issued to be looked into or all these things, you hear it. This is the order. So, against the first order, all entire order, my lord, I have come to this honorable court, and my friend has filed a cross appeal stating that no, this contractor license can continue because first part he has succeeded. So therefore, he has filed the appeal against that order. So now, my lord, at these premises, before
so the findings, single judge's judgment has been kept under abeyance by this.
Yes, I got an interim order.
So what happens? He's not in service then?
No, he's not. Another person, my friend, is appearing. He is continuing from 92, my lord, a trained person. He's not getting any salary.
He has not been approved till today, my lord.
Yes, because of this litigation. Yes, so now the only point, my lord, if you summarize everything to a point as to whether this honorable single judge order is valid, for the reason is whether there was a requirement of training qualification for appointment as a 10 graduate teacher. The honorable single judge said
the same order, he's filed a separate appeal.
Yes, he filed the appeal against the second part of the order, remitting the matter to the director with regard to that contract license. Only this is. So now, my lord, first point decides everything, whether a training qualification is required or not. So only one paragraph I will say, my lord, where the honorable judge has said, the single judge has said that training qualification is not required, and I will show the law. Only that will decide virtually. This is a voluminous brief, but this is the only summary.
For us, it's very conveniently not voluminous. We are paperless.
Pardon.
That's an advantage. So we have which you do not have.
So kindly,
yes.
Only the finding starts of the honorable single judge from paragraph 10.
So shall we commence after lunch? It will take some time.
Yes,
it will take some time.
We'll take after lunch. Soon after lunch.
Number 20. Item 27.
I have not been able to get any communication, but my lord, I have verified there is no interim order in my case.
Correct.
As a result of which the order ought to have been complied with.
Yes.
I undertake that I'll insist that order is to be complied.
Then we'll not interfere, sir. That's.
I'll see that the order to be complied.
You say by the impugned order dated 7th March 2019, the learned single judge has only remitted the matter to the disciplinary authority to reconsider the case of the respondent in light of the two earlier individual cases of supposedly similarly situated persons, namely Ramnath Lakra and Stephen Khalko, and to take a decision on the basis of the findings arrived at in those two cases. Full stop. It has further been clarified that the respondent would not be entitled to back wages. Full stop. Considering the limited nature of relief granted to the respondent, the court sees no prejudice being caused to the present appellant by the above directions. Full stop. Paragraph. It is directed that if not already implemented, the above directions of the learned single judge would be implemented by the present appellant within a period of 4 weeks, preferably after giving the respondent a hearing.
Yes. Actually, they've already heard. Now, only order of punishment has to be taken into consideration, nothing else.
Or within for 4 weeks, and the decision be communicated to the respondent within a week thereafter. Full stop. With the above directions, the writ appeal is disposed of.
Grateful, Your Lordship.
All right. Item number 35.
My lord, though Mr. Patnaik appearing for the petitioner is not continuing in the railway panel, but if your lordship permit me to place the CMAPL before your lordship.
Yes, we permit, sir. We permit, madam.
The petition paragraph 3, my lord. The advocate's clerk of Mr. Patnaik missed the list.
All right.
That day. So that's why he could not be present before this honorable court to place the matter. So that is the only reason, my lord. That is not deliberate or intentional.
No, what is the main writ petition about?
That petition I am not ready, my lord. Promotion matter, challenging the Honorable Central Administrative Tribunal. Order passed by Central Administrative Tribunal. I am not ready on writ petition, my lord. I pray for some time.
Somebody is appearing for the opposite party, no?
Yes. Central Government Council, my lord.
No. For the opposite party, somebody is appearing? No.
Opposite party, yes.
Somebody appeared?
CMAPL.
All right. In the writ petition also notice is not issued. That's what the amazing thing is. Since no notice was issued in the original writ petition itself, the court does not consider it necessary to issue notice in the present email 57 of 2015. Except for the reason stated there, the application is allowed. And the order dated 6 January 2015 dismissing writ petition civil 19053 of 2008 is hereby recalled. The said writ petition is restored to file. Then in writ petition civil 19053 of 2008, see list before the roster bench on 2nd January 2023. The first line will be, this writ petition is restored by the order passed today.
Item number 37.
Please, my lord. This matter, my lord, is covered by a lordship's judgment, my lord, in Keshav Automobiles, and thereafter, my lord, confirmed by the Honorable Supreme Court. So if my learned friend will take instructions in this matter, my lord, that will suffice.
According to Mr. Kara, learned counsel, the petitioner, the issue raised in the present writ petition stands covered in favor of the petitioner with the judgment of this court in Keshav Automobiles. Was the state of Orissa, which has been affirmed by the Supreme Court of India.
I've given the doubt.
By its order dated 13 July 2022, in SLP Civil 9912 of 2022, bracketed Deputy Commissioner of Sales Tax, Mrs. Rati Steel and Power Limited. Counsel for the counter. Respondent seeks time for instructions.
Email.
All right.
Annexure 1, no coursive action pursuant to annexure.
No coercive action be taken.
No, 19, my lord, this matter was withdrawn. It was filed in time. There were certain defects. I've given the affidavit. It was withdrawn to refile with better particulars, and that permission was granted. That declaration is there, my lords.
All right. List on 3rd January. You just say notice, he accepts notice and seeks time for instructions, and then say, till the next date, no coercive steps will be taken.
Pursuant to Annexure 1.
Pursuant to Annexure 1. All right.
May I just humbly pray, sir? Item 38, it's a very awkward position for me to make a submission. On behalf of Mr. Harish Chandran, my lord, I had requested a friend of mine, I was held up in another court. So this is a fresh matter. So I understand that your lordships have been pleased to keep it to March. So may I pray for an early date?
Early date, is it?
Lord, may I pray for sometimes in December, not next week, but at least in first week of December. I'm sorry for the inconvenience, my lord.
No. What is 9? 15 December.
15 December. Greatly obliged.
All right. The date in 38 will be changed to 15th.
Item number 39.
39, you have lordship not challenging the decision of the commissioner directing the fine. Yesterday, lordships, item 51.
Same order.
WPC 27569 up to 2020.
Same order as yesterday's item.
It is not uploaded yet, but that is the
all right. Same.
Another 67 by Mr. Patra. This is
here I have challenged the demand notice and order of the commissioner, where I have applied for surrender and I have deposited the entire license fee. I have not operated in a single day. There is objection and the law and problem was there. I provided 2 sites. That was rejected by the commissioner. But I applied for surrender. Entire license fee for the 21-22 I have deposited. Now he is directing that you pay the MGQ, entire MGQ.
Commissioner.
That is not a rule. Section 59 says that he licensee will apply for surrender.
So you can go to the
license fee.
So you can go to the secretary against this.
Yes, my lord. Against that, Annexure 12 order of the commissioner is revisable on 6. He should go to.
No, but here commissioner is the authority. Section 49.
The revisional authority is there to rectify the mistake of the excise commissioner's order.
Surrender with regard to the decision authority is commissioner. But he has not decided he is saying that you deposit the MGQ duty. I have not operated. I have not opened the shop due to public objection. The shop was closed. The lot of decision of this honorable court that I am not liable to pay. However, my lord, I have deposited the entire license fee for entire year.
My lord,
21-22 I have deposited. They directed. Your application will be considered if you will deposit the license fee. I deposited. Thereafter, they come forward another notice saying that you deposit the MGQ duty.
So far
Section 59 clearly says, Lord, 59(2)B, your lordship kindly have glance, 1B, on payment of the fees payable for the license or the consideration money due for the exclusive privilege for the whole period for which it had been current for such surrender. For surrender of license, I am liable to pay the license fee. And under the proviso, if it is accepted by the commissioner, then he will direct for refund of that money.
So let it go back.
Yes,
my lord.
Let it go back to the commissioner then.
No. The commissioner's order he is challenging in this writ petition. My first submission is that it is revisable under Section 6 and that is being done in all the cases, commissioner. Number 2, if your lordship will say that this order is to be examined by the honorable court, then I have to file the counter affidavit.
All right. Say notice, Mr. Manti accepts notice and seeks and is granted 4 weeks time to file a reply majority the next day. So till the next date of hearing, the impugned order dated 13 October 2022 of the Excise Commissioner shall remain state.
But they're again demanding on the person to the commissioner order, they're directing deposit the amount. That's why I applied for.
One way to do it is we stay the demand of MGQ.
Yes.
And direct him to decide on the issue.
Yes, that will be better.
Yeah, he has decided
the law
against him. That is to be tested by this honorable court.
All right. Shall remain state. All right. Till the next date.
Obliged.
List on. (27th February).
Obliged.
Supplemental list for hearing item 92.
So both these will be after lunch. We'll do it after lunch.
And you are seeking time because I have CPI region has not served. I'm sorry, let's keep it next week.
All right. You see, at the request of Mr. Satpathy, what are you serving?
And the reply to the regender filed by the petitioner.
Oh, Mr. Satpathy states that he's filing today.
No, I have already filed. Copy as not.
Oh, I see. Mr. Satpathy is served on counsel for the
Income
petitioner. Copy of the reply to the rejoinder today.
So a short date may be fixed.
Not possible, madam. 6th March.
Sure, 6th.
Beg your
6th March.
Yeah.
Can I
Beg your
pray in
pardon?
January? May I pray for
What's the
January?
hurry? What's the hurry?
Beg your pardon, Millard, that STRE we list. Let's see that 100 cases. Let's see if will be taken up. after.
Yes. We don't take up those matters at all otherwise.
I am suffering from fever for the last 4 days. But if your lordship will appear, because in all the 100 cases I have to appear.
Correct. We'll have a good disposal, so it'll all be over now. Within 1 month, 1 hour. Yeah. All covered also. It'll be all over soon. Then. I'll have it pronounced.
But the impugned judgment starts with page 221, annexure 16. Without wasting time, let me take my lords to the findings. Starts with paragraph 10. 234. May I read, madam?
Yes, please.
Paragraph 10. There is no denial to the fact that the petitioner, being a graduate having BA qualification, was recruited as against trained graduate teacher in a duly constituted selection process in an absolutely private, recognized, honored educational institution. There is also no denial to the fact that there is no rule governing the field of educational qualification for a private, recognized, honored educational institution. This is not a fact. Well, we have not. The dispute arose when the petitioner school became an aided educational institution with effect from 1/6/94, as notified on 6/5/95. Now, counsel for the petitioner submits here that in absence of any statutory rule in the field dealing with the educational qualification of teachers in unaided schools, there was absolutely no requirement of one being a trained graduate in an unaided school. This submission of the petitioner is being opposed by the land council for the opposite part number 4. I was the opposite number 4. On being putting that on 21/3/1990, board issued an ultimatum to the school with regard to the appointment of trained teachers, and in absence of which the school may not be allowed to place the students to appear in the HSC examination 1990, Annexure A/4 series, page 101. This letter was followed with another instruction by the board on 26/8/89. It is also submitted that since the particular institution failed to comply with the direction of the board, the institution was derecognized and the students were directed to appear as a quasi-regular candidate. And it is in this view of the matter, the managing committee was also constrained to issue so-called notice to the petitioner on 6 charges as available on Annexure B/4. Finding the reply of the petitioner not convincing, the newly constituted managing committee, after a threadbare discussion on the issue, resolved to issue 1 month notice before terminating this petitioner on 18/5/90, to which the petitioner did not reply. Consequently, the managing committee issued the termination order on 18/7/90. In establishing its case for removal of an untrained teacher, the opposite part number 4 placed reliance on the board's letter, as well as the provision contained in Section 7B of the Odisha Education Act, which provides the appointment of qualified teachers. It is relevant to take note provisions contained in Section 7B of the Odisha Education Act, which is quoted under Section 7B. Appointment of qualified teachers. The state government or any officer or authorized by it may prescribe the qualification be possessed by person for appointment as teachers, including the norms relating to requirement of such teachers in different categories of private education institution. Every private education institution shall, in order to recognize by the government, appoint the required number of qualified teachers as provided in subsection 1 from out of the list of candidates selected for this purpose by the selection board for this or concerned district, as the case may be, constituted under section 2 of section 10 of the prescribed manner. It is necessary to note here that section 7B was included in the Odisha Education Act for the first time by virtue of the Odisha Education Amendment Act 1988, and it came into effect from 14/8/1989. By this enactment, the statute for the first time gave an authority for prescribing the qualification to be possessed for appointment of teachers, including the norms relating to the requirement of such teachers in different categories of private educational institution. And by bringing such amendment under surplus 2, proviso has been made surplus 2 provision has been made directing the private educational institution in order to have recognition by the state government appointment the required number of qualified teachers provided as in subsection 1 from out of the list of candidates selected in this purpose by the selection board for the state or concerned district to be constituted under subsection 2 of the section 10 of the prescribed norm. First of all, this provision is prospective and should not have been applicable to the untrained teachers who have already been recruited prior to coming into effect of this amendment provision. Secondly, since the subsection 2 of section 7B of the Odisha Education Act 1988, the said provision had come into effect after the further amendment to the said provision brought in the year 1994 by the Odisha Act of 13 of 94, wherein it is prescribed that every private education institution shall appoint qualified teacher and non-teaching staff, again with a retrospective effect, but without affecting the teachers who are already in service at this point of time. Those provisions, to my view, have application to the petitioner's case. During course of argument, land counsel for the petitioner submits that even after amendment by virtue of Act 13 of 1994, neither any qualified or of the any qualification of the teachers nor any procedure has been prescribed in relation to private educational institution. Non-applicability of the Odisha Education Recruitment Condition of Service Teachers and members of the staff of aided education institution Rule 1974 to the private unaided schools is the subject matter in this court in a number of litigations such as in 2001, 1 Weller 233, 1991 Weller 468, 97 2 Weller 122, which matters were disposed of taking the above proposition clear by holding that since the qualification of B.Ed training become mandatory from 18/12/93 for an aided and government high schools, and further the under Annexure 4, the Director of the Secondary Education Odisha by Order number 8783 dated 30/8/93 has extended 2 years for teachers in non-government high schools get in appropriate educational qualification, and considering the fact that the petitioner cleared B.Ed on 28/5/1991, petitioner not having the B.Ed qualification in the year 1988 would not have an effect his services, and if there was any impediment on account of letters from the Board of Secondary Education Odisha by Annexure Y/4 series, nothing prevented the managing committee to take up such issue in its legal spirit with the Board of Secondary Education Odisha. In the above premises,
pursuant to the interim order passed on 8 September 2015, he has not come back to service, is it?
No, he didn't. He has crossed another person is coming.
No, he has crossed the age of superannuation, or he is not?
No.
My lord,
His age will be
the person who has been appointed against me, myself. He has also not accepted by the authority, and his service was not approved.
What is your age?
He is continuing.
What is your age?
My age, my lord.
His age was 51 in 2015. So it another 7 years, 58. But my lord, this finding
will take effect if my lord.
What is the age, retirement age for teachers?
60.
What will happen? What happened to that contractor inquiry?
Yes, I'm coming, my lord. So far this finding is concerned, I have to only 2 to 3 lines only to submit. This is the issue with regard to the training qualification. What the Honorable Court has held, that there was no provision in the statute by referring to Section 7B. But this is not the correct fact of affair. Section 7B is an amendment of the Act, but originally it was there prior to 1979. This was also there. And in Odisha Education Code, my lord, I'll just take the provisions of law first on this issue, because this is a law I can take. My lord, Odisha Education Act came into force in 1969. Prior to that, Odisha Education Code was holding the field. Prior to 1969. Odisha Education Code Article 312 provides for the qualification, that is the trained teachers. So the finding of the court that no, it is only 94 is wrong. Furthermore, kindly see first, my lord. Article.
No, go on. We'll see all that, sir.
Yes. Then
qualification is trained teacher.
Trained.
What does that mean?
BA BEd. Because this post is trained graduate arts. That means BA BEd.
I see.
That, and the rule, my lord, say plans. The Honorable Court has not taken the pre-94 rules. What is the Odisha Education Code? And the other one, kindly have a glance. This was the condition all through, my lord. This is his appointment in 85, according to him. In 1979 rules, kindly see, Rule 3. For establishing an institution, I have given the guess of this rule. Kindly see. The second page of the first. This is the rule is the Odisha Education Establishment Recognition of Private High School Rule 1979. So kindly Rule 3, my lord. Submission, enquiry, application for recognition. To get recognition, because this concept of permission came in 1989. Prior to that, a recognition was to be given. But prior to getting recognition, the edition, my lord, kindly see 3K, small k. The next page, my lord, small k.
Institution will provide requisite number of qualified staff.
Yes. The institution will provide requisite number of qualified staff as per the norm laid down by the board and the state government with emphasis suitable. So now what is the state government prescription? That will be there in the book itself. Page, my lord, this new book, 1089. There is a yardstick prescribed by the government. 1089, my lord. This is the government of pardon. 1089 page.
This page has only 1070.
Again? Oh, sorry. Then this book, that is there. My lord, Justice Raman is holding.
Yes.
1089. Yes, it's that. The other book also it is there, my lord. I can find it out for mine. My lord, but take my book also.
Yes,
it's there. My lord, kindly see the yardstick. Government of Orissa Education Department from N.P. Parija, IS Deputy Secretary, to the Director of Public Instruction. Fixation of standard tab for non-government secondary schools. That means high school. I am direct to say that the question of fixation of standard tab for the non-government secondary schools has been felt necessary by the government due to introduction of the revised syllabus 10 years under 10 years school pattern. After careful consideration of various aspects, government has...
So trained graduate.
Pardon me?
Says trained graduate.
Yes, ma'am. So 79 rule prescribes that it should be a qualified staff, and as per the government norm, and government says it is 10 graduate. So the judgment, my lord, the single judge has held that Vivekananda's case was also again distinguished by another division bench of this honorable court, wherein the common was one of the judge. Honorable judge, in that Manmohan Tripaঠি's case also, this issue was also raised. I've got the voluminous of this. In different points, but only one judgment also, my lord. That is the first judgment that Manmohan Tripaঠি's case, 99 2 LR 185. My lord, kindly tend to paragraph.
But there they give him a chance to obtain the training. There, they give him a chance.
Yes, we have given him chance right from 1985.
But he's got the B.Ed now.
No, he got B.Ed after the termination.
91, he's got it.
Yes, after the termination. 90, he was terminated. And by practicing fraud and by forging the signature of the secretary, he could have managed to go to that distant education. That is also a reading of my petition, entered petition. And he got the training qualification. But before he passed the training qualification in 1991, he was terminated in 18790. And other person have been appointed, they have been continued. And he has virtually, and what about the finding, kindly see, my lord, at this juncture with regard to, so my lord, I think my lord is quite satisfied with the fact that there is a requirement of trained teacher. So that is the requirement of law. But the Honorable Court has gone in a wrong direction and held that no training is required and then not.
Let him answer. Yes, sir.
But with regard to the contractor license, my lord, kindly see.
If you succeed on this, where's the question of contractor license?
Enter. Referring to WN number 121. My lord, the petitioner having the my lord, two notes, my lord, on this point. Decisions are there, my lord. I have complied. My lord, the petitioner was selected for arts graduate teacher and joined on 11085 in the due process of selection. Not only the petitioner was untrained teacher, my lord, having BA qualification, other two teachers were also untrained teachers, saying that. My lord, after joining the school, there is a provision introduced by the Utkal University. Your lordship kindly come to the writ appeal number 121 of 2015. That brief I am annexed, my lord. Your lordship kindly come to page 2, page 33, annex 2.
Yes.
Utkal University introduced a corresponding course for undergoing the BEd training because there was not sufficient training institution in Orissa. And most of the graduates were unable to undergo the training. Even the teachers throughout Orissa, untrained teachers, not only the private educational institution, but also in the aided educational were continuing. Your lordship kindly come to page 35, admission to the BEd course.
No, but this is for the prospectors of Utkal University.
My lord, their eligibility has been prescribed. A teacher,
but that's not even the issue, sir.
My lord, page 35.
That's not the issue here. The issue is not about whether you're eligible to take a B.Ed course or not. That is not even the issue.
My lord, when I was appointed, my lord, I was undergraduate.
Was there a requirement for you to be a trained?
No, there is no requirement at all, my lord. It is the service in a private educational, is a contract. It has been decided by this honor court in 2 judgments. And as there is no rule to prescribe the qualification.
There is a rule, sir. He's just shown us that rule.
2 judgments.
Come to this circular at page 1089.
1089
of this book. You can show him the book, sir.
Yardstick. 8781. That has been introduced, my lord. That I have seen, my lord. That 8781 circular. That is.
What to say for that?
That was prescribed, and those have been interpreted because, my lord, in aided, subsequently this institution becomes aided one, my lord.
So even for unaided, sir, this applied to unaided.
Yes. Unaided educational institution, my lord.
Non-government.
Non-government school.
Standard staff for non-government secondary schools, sir.
My lord, non-government secondary school includes both unaided and aided.
Whatever, so it applies.
Aided and unaided, my lord.
Correct.
And these provisions have been interpreted by in number of judgments.
So you only have judgments now.
That dispute comes, my lord. Therefore, judgments have been interpreted by this honor court. My lord, first your lordship kindly come to Aurobindo Pandya's case reported in 2001, OLR 233.
Yes.
Placing paragraph 10 of that judgment.
enter, my lord, it has been taken into consideration. Para 6, from para 6 to I am placing my lord. Undoubtedly, the petitioner was appointed as an assistant pundit by the managing committee of the institution on 292. Admittedly, on the said date, the institution was unaided, and admittedly, the petition did not have the requisite qualifications for the appointment. Now, the question is to whether the appointment of petitioner was regular, legal, or not. Section 10 of Orissa Education Law follows.
My lord is asking something.
Pardon.
Please refer to the page.
Page, my lord, that is, I am not paging, perhaps. Aurobindo Panda's case I have given, my lord.
Yes.
In that compilation, it is there, my lord.
Yes. What is the page number?
It is, I have not judgment.
No. I have got the judge.
Mahapatra.
Yes, my paragraph 6 of that judgment. Paragraph 6, my lord. Let me place paragraph 6 of that.
Carry on, sir.
On disputedly, the petitioner was appointed. Do you also get it, my lord?
Yes. Assistant Pundit.
This was appointed as assistant pundit by the managing committee of the institution 2/11/1992. Admittedly, on the said date, the institution was unaided, and admittedly, the petition did not have the requisite qualifications for such appointment. Now, the question is as to whether the appointment of petitioner was regular, legal, or not. Section 10 of Orissa Education Act runs as follows. Conditions of service of staff of aided institution, the qualification required for appointment as a teacher and other members of staff, aided education institution, and their conditions of service relating to the salary, leave, pension, provident fund, age of retirement, disciplinary action, and other matters shall be as may be prescribed. The said section only speaks aided educational institution has no option to an institution which is unaided. The Orissa Education Recruitment and Conditions of Service of Teachers and Members of Staff of Aided Educational Institution Rule 1974 also prescribes the procedure for appointment of teaching staff in aided educational institution, and the rules have no application.
So the problem is this.
Yes, ma'am.
He's relying on. Have you given him copies of this?
Judgment copy, ma'am.
No.
The rule. Rule I have copy. I have rule, my lord.
See, he's referring to
the qualified teachers, my lord.
No. He has referred to Orissa Education Management of Private Colleges Rules 1979.
Private high school. Management private schools.
And Orissa Education Establishment and Recognition of Private High Schools Rules 1979.
Yes, my lord. I have given the copy to your lordships with this copy.
This judgment which you are referring to, Arvind Panda, is not referring to these rules.
Yes. That is the point.
Arvind Panda refers to Orissa Education Recruitment and Conditions of Service of Teachers and Members of Staff of Aided Education Institution Rules.
My lord, they are, my lord.
Admittedly, the school was not an aided school.
Not aided school.
So why are you referring to a judgment which refers to rules applicable to aided?
No, it is in respect of honored school. Therefore, it is
Arvind Panda is aided educational institution, sir.
No, that was subsequently become aided, my lord.
Sir, anyway, Arvind Panda will not help you because it refers to a different set of rules.
No, same rule, my lord. Under same rule, this school is governed, my lord. Your lordship, let me place, my lord, that. Under same rule, my lord. Not other rule, my lord. Only those rules are available.
Sir, it is not the same rule, sir. What he has given, I don't know whether you have a copy of this.
My lord, that has been discussed here only. That other rules have been discussed.
Where is it? Where is the discussion?
Placing.
Where is the discussion? Where is the discussion of the 1979 rule? There's no discussion.
That rule, my lord, that rule has
in Arvind Panda, it's not discussed, sir.
That rule has not been discussed, but it has been decided. You will also kindly come to para 10, my lord. Aurobindo Panda was appointed in an unaided institution. Subsequently, my lord, that became aided one with 1694. And his service was not approved as he had no qualification. He acquired a qualification in 2000, my lord, 2000 somewhere, 99 or 2000. As he paid for service, he filed this petition, and it was held that in a private educational institution, the qualification was not prescribed, and taking into account qualification in the aided educational, his service was approved.
You've understood what the question is.
Yes, right? I understood, my lord.
All right, then that's okay. As long as you understood, it's fine. Now you carry on arguing, sir. No problem. Yes.
Let me place my enter. My Lord, 70 also prescribed the procedure appointment of teaching in an aided educational institution, and the rules have no application so far as appointment in non-aided educational institutions concerned. The learned additional government advocate has not been able to cite any provision contained in the Act that's governing the appointment of teachers K of 1991 rules.
At all. But he says he's
My Lord, your lordship is specifying questions. As rule has been provided in 1979 rules, the qualified teachers is to be appointed, my Lord. In 79, my Lord, when the rule was framed, no qualification has been prescribed for unaided educational institutions.
Not true, sir. Not true.
No rule has been framed, my Lord.
My lord desires to know whether these judgments have taken into consideration this yardstick.
No. This rule has not been taken into
Yes, that is
because
what-
it has been held that no qualification was prescribed in an unaided educational institution. My Lord, 79 rules, my Lord, I'm placing to the 79 rules that in compilation I have given, my Lord. I'm taking to loss.
In addition, he's also cited a judgment, sir, Manmohan Tripathi, which recognizes what he's trying to say, supports him. There, a division bench has held that for an untrained, as a trained graduate is an essential qualification.
Trained graduate qualification, my Lord. My Lord, that your lordship kind come to this 1979 to 61 page. I am taking this boy must know. I've given the.
Not considered.
My Lord,
that's the whole thing. There needs to be 2 lines of judgments.
ठीक है prescribe, my Lord. Provide requisite number of qualified staff as per the norms laid down by the Board of State Government within emphasis suitable staff competent to teacher series and mathematics, my Lord. My Lord, Board has not prescribed that qualification, and Government has come with a circular on 8781 prescribing the standard staff, my Lord. That will be the 4 trained graduate teachers and 1 headmaster having 7 years teaching qualification, my Lord. This is the qualification prescribed under 8781, my Lord. My Lord, this 8781 circular was not given effect to, for which, my Lord, that no rule was framed, and this Honorable Court takes into consideration the rule of subordinate education service 1972, my Lord, and subsequently 1993 subordinate education service 1993 were interpreted, and by interpreting the statute, it came to the conclusion that an untrained teacher can be appointed in unaided educational institution, my Lord. And subsequently, when the school becomes aided one, even till 1993, my Lord, 1812, 1993, one untrained teachers had the minimum qualification to be appointed in the institution. Therefore, I am citing those decisions, my Lord, in Gaur Devi case, 1997 to Vivekananda's case, my Lord. And the government provided, my Lord, that 2 years that has been dealt by the Honorable Single Judge, a circular came with the government that the teachers who have not having the training qualification, my Lord, 2 years have been granted to have the training qualification. That has been dealt by the Honorable Single Judge, my Lord, in that way. My learned friend read that portion. That has been taken into consideration by the Honorable Single Judge, my Lord. I am placing that portion only, my Lord. Judgment. In the judgment, Paragraph 10, my lord. Document कितने 121 हाँ हम फाइल कितने होती 221 Yes, my lord, page 236.
236 of what?
The government provided 2 years relaxation for acquiring the training qualification. Those who are not having the training qualification, 2 years have been given by the government to have the training qualification, because on 87821 it has been prescribed for first time that a trained graduate teacher is required to be appointed, and the training.
But you didn't get the qualification, so you got the qualification 91.
91, my lord, I was sponsored as an in-service candidate by the school.
No, even if it's a 2 year relaxation, you were appointed in 85.
Yes, 2 years relaxation was given in the 1993, my lord.
By which time you were terminated, sir?
My lord, at that time, I have already completed the training, my lord. And what they did, my lord, they substituted another on-trained teachers in my place, my lord.
That's neither here nor there, sir. The question is whether you were qualified or not. That's all.
I was qualified, my.
There's no negative equality here.
My lord, as I was not qualified, then I was sponsored by managing committee to undergo the training. At the time of completion of termination, I have already completed the training. Only result will be to publish.
Anyway.
My lord, one judgment is there, my lord, by the Honorable Ashri Patnaik then that if the managing committee has sponsored some untrained teachers to undergo training, and he acquires the training and completed the training, he should be allowed to continue in the service and he should not be terminated at all. That judgment I am fighting before Lord's System.
Niranjan Bera.
That is case of Niranjan Beura versus State of Orissa.
Correct. All right.
I'm taking to a relevant portion of that judgment.
Right.
And paragraph 6 and 8 2 paragraph I am placing.
Yes.
In similar case, Dhaneshwar Naik and State of Orissa and others, which came to this court, the management refused to grant the teacher study leave. When he wanted to join after here I have been granted the study leave, my lord. After completing the training course, he was not taken back. So he moved the High Court without approaching the Education Tribunal. Court held that following the earlier decision in the Upendra Pradhan versus State of Jagannath Prasad ME School and others, and Durjodan Tarai and another versus Managing Committee, Patri Sai ME Schools and others, and OJC number 664 of 1976 decided 26/4/1978 that refusal to take back the teacher after he completed the training amounted to termination of service and was violation of section 10 of the Orissa Education Act. Refusal to allow the teachers to rejoin the school. That's what happened here, my lord, in my case. Rejoin in the school after completion of the was held to be violative of section 10A of the Orissa Education Act. The order was declared void inasmuch as management were habitual in refusing to take back the teachers after completion of their training. The additional Director of Public Instructions Orissa issued circular number so-and-so on 17/6/1977 to all district inspector schools, drawing their attention to the conduct of certain managing committee who were not allowing the teachers to rejoin their post after undergoing the training, observing that such conduct of the managing committee was illegal. The teachers who wish to rejoin their former post after completion of their training should be allowed to do so. Then Parai, in view of the settled position of law, this court refusal to allow the petition to rejoin in its service having been terminated, which is stand in paragraph 13 of the return submitted by management, the petition continues to be in a service and entitled to be reinstated, my lord. Here, my lord, before termination, my lord, I completed the training and I came to join in the school. They did not allow me to join. Then I repented to the inspector of schools. Inspector of schools, my lord, called the managing committee and directed to allow him to discharge the duty. They did not allow, my lord. Then they served me the termination letter just after 1 year, my lord. When I got the termination letter, my lord, then I filed the appeal before the director, my lord. That I have already completed training. The result of the training has already been published. I am a trained graduate teacher. I should be allowed to continue as per the judgment of the Honorable Court, my lord. I have already completed the training, and the managing secretary has sponsored me to undergo training, and the educational authority has approved it for undergoing training, my lord. As you will also kindly see the annexure, the appeal number 120, and I have annexed that document, my lord. You will also kindly come to page 41, my lord. My lord, annexure 3 at page 39.
Yes.
120 writ appeal. This is the application form for undergoing the training as in service candidate. I was in service. You will also kindly see page 41. It has been countersigned by the secretary of the school permitting to undergo training as in service candidate and duly approved by the inspector of school, Baleshwar, my lord. So I underwent the training, my lord, in the government institution. And after completion of training, they did not allow me to join and terminated the service, my lord. It is completely covered by Niranjan Beura case, my lord. So, my lord, that as untrained teachers, I was appointed out that requisite qualification because the no specific rule was there, only that 8781 circular was there. That was not given effect to, my lord. Therefore, the government in the year 1993, even, my lord, from stage to stage, granted 2 years time to all the untrained teachers throughout Orissa to undergo training within 2 years, my lord. Much prior to that, I have undergone the training as a service teacher, my lord. And completed training in the year 1991, my lord. The result was published in 1991. And during that period, they terminated the service by giving the antedate, my lord. Taught me in the year 1991, when I preferred the appeal, my lord. And further, my lord, before termination of service as an untrained teacher, my lord, they have not given an opportunity of being heard to me, my lord. They have not given an opportunity of being heard.
Going training, what is the procedure? You undergo training and you sit for an exam.
Training is a separate exemption.
No. My question to you is, you say you completed your training even before your termination.
Yes.
No. When did you actually complete training as per your list of dates?
That, my lord, I completed training, second page. I'm giving the date, my lord, specific date I am giving.
Because 5/3/1990, you underwent second phase of training.
Second phase of
till 25th March.
Yes.
Then what happens?
And my lord, I completed training after second phase. That is for near about 1 month. I completed.
No. So you complete training on 25th March.
Yes.
Just come to your list of dates, page 3.
List of dates, my lord.
Page 3.
Yes. 3, my lord.
Date 5/3/1990.
Yes.
The appellant underwent the second phase of training till 25/3/1990.
That is the last training period.
No, between that and the date of your B.Ed degree, which is
Because
28/5/91, what happens during that interregnum?
Interregnum, I allowed to join I came to join in.
No. I want to know from the course point of view, sir.
That course, that result was not published, my lord. During that period, result was not published.
For 1 year, they did not publish the result.
Yes, my lord.
No. Did you have to undergo any exam between these two dates?
Yes, by 25/3/1990, I completed the examination.
No, sir. One is training. I'm asking, apart from this training, is there an examination that you have to undergo?
Yes, my lord, that examination.
When did that examination take place?
Examination date, my lord.
B.Ed is that training.
No, a B.Ed may submit, my lord.
No. There is a practical part and there's a theoretical part.
Yes, I'm just practically. What training he has undergone is in a distant mode, in a correspondence course.
In the
correspondence.
Anyway, your rule doesn't say correspondence means does not
That
valid.
was in different phases. According to his document, I have found out from their court. Though he claimed to have been admitted to the course in sometime in 90, but his examination and result was published.
Examination was within that period, my
91.
Was it in his control, sir? Was it in his control?
Regular in the process. Because
what is the process? You explain. If he's not able to explain, you explain.
Yes, my lord, as per his document, he has undergone in distant mode. It is a correspondence course. Because it is not a regular course of training. Because a B.Ed training at the relevant time was 10 months course. 1 year course. Ultimately, it is 1 year course. And regularly, after a completion of the course, one is to sit in the exam. But for them, it dragged for 2 years. Because they have to sit in the examination, they have to get the materials from the university and they will prepare themselves. Thereafter, they will ask to appear the examination in phase manner, different paper, different dates. So it took 2 years.
No.
So there is no delay on the part of the university.
No. You come to page 3.
No, man.
Of the
his list of dates.
List of dates he has not given. My lord, this list of date is there. He has given the prospectus.
No.
Can you see Annex 2 in his petition? The prospectus, I have read through this prospectus. List of date.
So internal page 3 of that list of dates. Yes. There is a date 5/3/1990.
My lord.
Kindly read that, sir.
Yes, the appellant underwent the second phase of training till 25/3/90 after being duly permitted by the inspector of school and duly relieved from the school. The constitution of this is the date, my lord.
So this is the date on which he completes training. Yes. All right.
It is his statement, but what the I was
kindly listen to the question, sir.
Yes, ma'am. Sorry. Yes, ma'am.
Is there a requirement of the course that after completion of training, a person has to write an examination?
Yes.
Is there such a requirement?
Yes. Examination is followed after the course complete.
From where are you saying this?
Because that is, my lord, kindly see the prospectus he has given. The entire prospectus and under which he has gone the training. Page 33 of his appeal. Read appeal 121.
You take us to the relevant portion, sir. Don't make us read line after line.
Yes, my page 36, clause
34.
First, 34, 36, clause 10. Utkal University conducts BD exemption once a year. In matters of exemption, prescribed regulations of Utkal shall be followed. The fees for exemption shall be prescribed by the university from time to time and will be intimated the students.
So you knew very well, since you permitted him to...
No, that is not the case. My case is we have never permitted him.
No. You can't simply say that. I'm sorry. Just come to that 24/1/1990.
That is a fraudulent document that I have stated. That is the case. Which one?
That is not even there before the single judge. It's a fraudulent document.
Yes. I have filed the counter by stating the document. I have filed my counter also.
And inspector has also counter signed. After he submitted by the school not by I have handed over. They report to the school. Inspector, managing committee report to the inspector school. Inspector school approved it. Thereafter, I got the admission in the training correspondence course.
Kindly see
his service candidate, my lord.
Kindly see his prayer. How could we allow him? The inspector is saying that managing committee is not there. Kindly see page 55.
The managing committee. was there at that time. Managing committee was there till 89, 1989.
Brief.
Yes.
Which brief now?
Sorry, ballot 121. Writ appeal 121. My friend's writ appeal.
Yes.
Yes.
Managing committee, according to managing committee, continued till 89. It is 11/8/89 the application.
I'll kindly see. What is the point I'm just reading out? This is Office of the Inspector School, Balasore Circle, Balasore, to the Headmaster Padmalochan Mundahan High School, Jadivali, allowing to undergo training. This is to inform you that as the managing committee of the school is defunct, the undersigned in the capacity as the special officer of the school requesting you to allow Sri Deepak Kumar Ghosh to undergo B.Ed training under the correspondence course in Government Training College, Balasore as prayed for. What document he has filed? A signature of a secretary. Governing body. Headmaster is not the secretary.
That is when my lord, after
sir, I am reading what you are saying.
When after getting
your document,
the first phase of training was called for, my lord. At that time, managing committee was not there, my lord. When I applied, managing committee was there. In the year 1991, when the secretary did not allow me to, the headmaster did not allow me to undergo the training, my lord, first phase, the inspector directed the headmaster that to relieve him to undergo the training. Then headmaster relieved me, I underwent the training, my lord.
No, Mr. Das, this page 55 which you read,
yes,
this is a valid document.
This is the document of the Inspector of Schools.
No. So this is a valid document.
Yes, ma'am.
So inspector has permitted him to undergo training.
No, inspector has not permitted. Inspector says, can you see the memo again? Yes. I have read out. He has said, directed the headmaster of the school to allow him to go on training.
What does that mean?
No, headmaster isn't, because this is an unaided recognized institution. Under the rule, my lord, the secretary is the chief executive of the managing.
But the managing committee is defunct, sir.
Managing committee defunct. So therefore, application submitted by him to the university training should have been allowed by the concerned headmaster of the school. But it was never done so. He has filed the application. Are sir, wait for. He's saying headmaster is not the authority.
At that time, when I applied, management was there, my lord.
He is contradicting his own statement and document.
No, I am not contradicting.
Allow me to speak so that I can finish it within 2 to 3 lines. My lord, this is the letter of the inspector. And inspector of school in that particular letter also cautioned him. And you see the memo of that page 55. Copy forwarded to Deepak Kumar Ghosh, assistant teacher, so-and-so, information reference, dated 27/12/89. He is instructed not to make direct correspondence with the undersigned, ignoring the immediate superior. That is means the headmaster. And he has filed an application form for B.Ed application form, which purported to have been signed by one Rudananda something, is a 4 signature. He was the secretary. He is not the headmaster. And let him produce one document, my lord, that application for B.Ed was allowed by the headmaster as per the direction of the inspector of school. I have no case. It is not a fact. That is the document he has filed. It has been allowed by the so-called secretary.
No, my lord.
What you are saying?
My lord,
this is your document.
Let me submit, my lord. Managing committee was approved on 10/1989, my lord. 86, my lord.
Kindly see. His application form is there. Kindly see, my lord. Page 41. No, don't mislead this code. No. Page 41. Kindly see the application form he has filed. Page 31 start annexure 3.
Yes.
What I am submitting, whether I am correct or he is correct. Yes. Kindly see.
Yes.
Page 39. It is his application form for B.Ed. Kindly see who has signed it. Secretary. Rudananda Behera.
Yes, I am.
Please allow me to speak, sir. Page 41. It is signed by Secretary PM High School, which is a defunct body. Inspector saying, no, it will not do. It is the headmaster to sign. And my case is headmaster is not signed. Not allow him to sign. He has purportedly manufactured document. It's a fraudulent document. He is prepared only to go for B.Ed training. And moreover, he passed the B.Ed in 25/191. We have terminated him 90. So this is the fact.
Let me on paragraph 3 of my appeal memo. My paragraph 3. That while appellant was working in the school, the management committee was constituted and was approved by the Inspector School Balasore by the office number 2286 dated 10/3/1986 for 3 years as per Rule 4(2) of Rule 6 of the Orissa Education Management of Private Schools 1980. I have given the copy that to your lordships. In the said Constitutional Management Committee, one Hudanda Behra was approved as the Secretary of Management. Term of the Management Committee was expired on 9/3/1989. And by virtue of the provisions of Proviso sub Rule 2 of Rule 6 of Orissa Education Management of Private schools rules 1980. The managing committee functioned for another period of 6 months. Due to non-constitution of managing committee on or before 1990, the additional period of 6 months expired on 9/9/89, my lord. I am taking to your lordships to the rule I have.
No, just come to page 55 of the.
Yes, 55 I am coming to, my lord. 55. 55 is the letter, my lord, that I am coming to. Prior to that, I am coming to lordship. I made an application on 7/8/1989. At that time, managing was there. Managing term expired on 9/9/89, my lord. That is the prior to 1 month, I applied the application. That was countersigned by the secretary, then forwarded to the inspector school officially, my lord.
But the inspector did not immediately grant that permission.
Now, immediately, inspector countersigned on 1989.
Where is that document?
That document, page 41, my lord. Yes. My lord, yes. 11/8/19.
It's not countersigned by the inspector, sir.
No, it's 12/8/1989. Countersigned, my lord. Thereafter, my lord, after taking admission in the.
No, but it's true that this was countersigned, then why in page 55 he should again write?
No, 55, what happened, my lord? I am taking to lawsuit. After taking admission in the institution, when they called for me to undergo the first phase of training, the headmaster at that time, management committee was not there. From 9/9/89, the management committee was not there. They called for me first phase training in the year date. I have given specific date. Then they did not, the headmaster did not relieve me. I wrote a letter at page 50, my lord, you will also kindly see, page 50, to the inspector schools. Request to sanction leave to undergo bid training, my lord. This is, I beg to inform you that I have serving as assistant teacher having qualification BA in PM High School, Jodibali since 1985. As I am untrained, I applied to undergo the bid training in correspondence course under the Utkal University, and as such, I was selected and admitted on 17/11/2009 through proper channel. The director of correspondence course has directed me to undergo the first phase of training in Government Training College, Baleshwar, only for the period of 12 days from 28/12/1989. Therefore, I request you to sanction study leave without pay for the period as the MC not functioning and obliged. Then, my lord, inspector school, thereafter, on the basis of my representation, the inspector schools passed the order on this annexure page 55, my lord. No. Directed to relieve me.
No. He directed page 55. Just read that carefully, sir.
Yes. No, to the headmaster, my lord. At that time, secretary was not there.
Correct. So see what he says.
This is to inform you as the managing committee of the school is defunct. That is on 24/1/1990. From 9/9/1989, managing committee became defunct. There is no managing the school.
Kindly read the letter, sir, please.
This is to inform you that as managing committee of the school is defunct, the undersigned in the capacity of special officer of the school requested you to allow Sri Deepak Kumar Ghosh to undergo BD training under correspondence course in Government Training College, Baleshwar, as paid for. That is for first phase of training for 12 days. Only to relieve me. This letter was written to the headmaster as the managing committee was not there. But I admitted, I made application in the month of August 1989, my lord. At that time, managing committee was there, and the inspector as well as
No. So pursuant to this letter, what happened?
Then they relieved me. I underwent the training.
No. Was there an order relieving you?
No. Order relieving me, my lord. No, the order relieving me, that is not which I am not annexed that. They relieved me. The fact remains, I underwent the training. Your lordship kindly come to. I have annexed the document, my lord. I have annexed the document. I mean, relieved by the principal of the government school, my lord, after undergoing the training.
Yes, the reproduction, we can't hold it some documents.
I've given that document. May I read his representation? His representation.
Let him finish. Let him finish.
Yes, his contradiction also.
No, what happened after 5th March? When did you write the exam? 7th May. Right.
7th
May,
May,
you write the
that
exam.
was antedated, that they did not give. Prior to that, they have given one later on 25/5/1990.
His control. Not even control.
Man, 2 times they terminated my service. On 24/5/1990, Annexure 17 in Odia language, the Honorable Judge, Mr. Justice Raman can read, my lord. That first terminated my service on 25/1/90. I am reading in English by translating it. At the Board of Secondary Education Orissa, on bearing letter number 7365, dated.
Where are you reading, sir?
My lord, page 66.
What's the date of that document?
24/5/90.
That's
that is first termination letter, my lord.
Okay.
It's not a letter. Then, my lord, they said that you have terminated your service, and prior to 1 month, we intimated you, informed you, your service is terminated for not having the training qualification. Then, my lord, for first time, after disposal of W for first time, in the High Court, they filed. They did not file any return before the authority, my lord. Then, my lord, before this honor court, they filed this document that we have terminated for the second time, that is letter dated
6/3.
7/5, my lord. That is in the 5. I'm giving the letter. That is on 18/7/90. At page 76, Annexure 21. 2 letters of termination, my lord.
No. One
Two
notice.
Not notice. It is not notice. Chakiru Abhayita Sambar you for regarding person of service.
Regarding.
Chakiru Abhayita Samparkar. My lord, Honorable Justice Raman can read, my lord, that in Odia. We have resolved to terminate your service on 18/5/1990 in the 44th resolution of the managing committee. And it is informed you before 1 month. That is the contents of the letter. Then I received this letter in the month of March 6/3/1991, my lord. After receiving within 1 month, I prepared the appeal as per the provision, my lord. Thereafter, they did not, my lord, bring with any document before the appellate authority.
So no natural justice.
And they challenged the order of the appellate authority, allowed the appeal. They challenged the appeal in this honorable court, my lord. In the honorable court, they produced a document that is 18/7/90 at page 76, Annexure 21, that your service has terminated on 46th resolution. If on 44 resolution they terminated my service, then again in another resolution they have terminated another for second time. I have already. And then what they did, my lord, in my place, another on-train teacher was replaced by me. And my lord, another teacher, Ramendra Kumar Jena, BSc science teacher, my lord, he underwent training along with me, my lord. He was kept. I have taken the pleading along with myself, my lord. Ramendra Jena also recommended by the managing committee. He took admission and underwent the training along with me, my lord. And his service was returned. He continued in service, and I was terminated on that ground, my lord, by replacing an on-train teacher.
So what about your appeal? Why have you filed an appeal?
Pardon me?
You have, why have you
my
filed?
lord, I have filed this application on the ground that this on the honorable single judge remanded the matter to the directorate.
Because you are a private contractor.
Private contractorship, my lord. Whether I attend, what is the consequences of my lord? That was not the foundation of termination, my lord. Here are two questions, which was not decided by honorable single judge, my lord. Orissa Amendment Education Act 1918 came into force on 10/8/89 or something date. And they say that by virtue of this 5 years, the term of managing committee by Amendment Act extended from 3 years to 5 years. Changed, my lord, not extended. 3 years to 5 years, my lord. They say that by virtue of that term was expired on 9/3/89, my lord, managing committee, actual term. Then 6 months as per provide 6 months is continued additional period. The term expired on 1989, my lord. The Amendment Act came into 1989. They say that by virtue of this Amendment Act, our term was extended for another 2 years, my lord. Because the so-called notice which was issued by the then former secretary, my lord, that was issued to me on
18/1/19.
No, that date, my lord, giving exact date. Issued on 13/1/1990.
13/1/19.
My humble submission that when the managing committee was not there is no managing committee. He has no authority and capacity to issue this so-called notice or charges framed against me. They became a nullity, my lord. Therefore, they have not even, my lord, the contractorship is a stigma. And if a stigma is attached to the termination of service, they should conduct a regular inquiry. The managing committee did not conduct an inquiry, did not give an opportunity of being heard, and terminated my service for 2 times, my lord. Therefore, the honored single judge, I have cited the decision, even constitutional decision, that the Amendment Act is prospective one. And if the amendment was done on 14/8/1989, the managing committee which is constituted after 14/8/1989 or on or after 14/8/1989, that committee will have only 5 years term, my lord. Those which have been constituted prior to 14/8/1989, the term confined to 3 years, that was approved for 3 years. Therefore, by giving the 6 months extension period, then it expired on 9/9/1989. Therefore, that shall not be extended at all. There is no managing committee after 9/9/1890. And managing committee was reconstituted and approved on 4/4/90, my lord. If it had been extended, my lord, then managing committee could have been constituted in the year 1991, my lord. But managing committee constituted on 4/4 from 9/9/1989 till 4/4/1990, there was no managing committee in the school. Therefore, the former secretary who has issued me to the charges, my lord, that is a nullity, and no managing committee resolution is behind it, my lord. Secretary is not alone empowered to issue a charge sheet, my lord. That should be passed in the managing committee meeting, approved by the managing committee. Thereafter, charges can be framed, my lord. Now, my lord, I challenge that contractorship, as it is not the foundation of the termination, and twice they have terminated my service on the ground that I am an untrained teacher, my lord. Then, the honored single judge should not remand the matter to the director to decide that I as a contractor during that period, my lord. The matter should be decided in confining to the termination, what ground they have stated in the termination order, on which ground they have terminated my service. They have terminated my service on the ground of an untrained teacher, my lord. They cannot take shelter that we have given another ground. In the constitutional bench decision, my lord, that is Shamsundar and others, my lord, versus Ramkumar and another, reported in 2001-8, page 24, my lord. Supreme Court case, page 24. I am referring to the para 28 of that judgment, my lord. No, my lord, that is wrong, my lord. So I made a wrong submission. Sorry, my lord, pardon. That is judgment is in Nehru. My lord, sorry, my lord. That constitutional bench, that is judgment is, my lord, 2008 to Supreme Court 4/7. 9, my Nehru Yuva Kendra Sangathan versus Mehboob Alam Laskar. You lordship can count para 16 of that judgment. I'm going towards bottom this judgment. I have two judgments.
Nehru Yuva Kendra.
My lord, that is Nehru Yuva Kendra Sangathan.
Right.
Yes. Para 16, my lord. That is only that foundation.
That's not constitution bench, it's only division bench.
No, it is not the constitution. It is the division bench. That is constitution regarding statute perspective. Para 16, my lord.
The respondent is appointed temporary basis.
The respondent is appointed on temporary basis who is put on probation. Indisputedly, the period of probation was required to be completed upon rendition or satisfactory service. Only in the event of unsatisfactory performance by the employee, the termination of probation would have been held to be justified. It is, however, well known that when the foundation for such an order is not unsatisfactory performance.
No, but here the ground for termination is not unsatisfactory performance.
Here, ground that they put that
the ground is that you are a contractor. That's all.
Pardon? It's on training.
It's not.
Yes, then the contractor does not come within the purview of termination, my lord. And even I have during that period, I have not received any money. I have not done a single work during my service period, my lord.
Yes, sir. Now you can start.
My lord. What is stated about his training? He has filed the documents in his appeal. Those application also he has filed before the Honorable Single Judge in the writ petition. There, my lord, at 55 and 41 I have shown. Kindly see what he has written is the representation to the director at page 67 of his writ appeal 121 of 15.
Yes.
Only 2 to 3 lines. 7 line from the top, my lord.
Yes.
After 7 line. At the time of joining, I was an untrained teacher.
Correct.
And after being duly permitted by the inspector of school Balasore, I took admission into the B.Ed correspondence course under the Utkal University on 2011-89. After taking admission, I completed the first phase of training on 8/1/90. This, if my lord will tell you the dates, it mismatches with the documents what he has filed at page 55. He says here, it is his representation.
Yes.
Inspector of school has allowed me to undergo training on 2011-89. What document he has filed, which I am saying it is a fraudulent document, 28/11/89. Kindly see what document he relied at page, his application form, page 41. It is a counter signature of the inspector of school, page 41. This letter of 7/8/91, counter signature by the inspector of school is 19/8/89. Towards bottom, my lord, it is not legible, but 19/8 as I understood, or at best 13/8/99.
Maybe 12/8.
My lord?
Countersigned.
Counter left hand.
19/8. I think it seems more like 19/8. Yes.
19/8/89. So what he says is he has allowed him in November. But this is in what I beg to submit. And two things.
They have given in the date.
This is the interruption. No.
Let him.
Yes.
My lord, this is the application form he has filed. So now, page 55, he says that inspector of school is saying headmaster is to allow him to go for the training. It is on 24/1/90. If he has already got admission in 25/11/89, the counter signature document he is filing now, that application form is showing to the court and file it here, is a fraudulent document for two reasons. The first one, signature doesn't tally, and secondly, the secretary was not the authority to sign it. As per the order of the inspector of school, it is secretary was signed, not the headmaster. So these are the two things.
Where's the question?
Thereafter,
headmaster, which rule says headmaster is to sign?
Pardon me, this page 55. The order of the inspector.
No, that is relieving, sir. You're mixing up two things.
Not relieving, allow him to undergo.
No. To him undergo training, please relieve him that letter.
No, that is already over. 8, what he says, my lord, kindly see page 68 once again. He says, that is why I have read first 67. He says, again I am reading page 67. After taking admission, I completed the first phase of training on 8190.
Correct.
8190 has completed the training.
Correct.
First phase.
Yes.
So there is no question of relieving him. Already relieved. Pardon?
For second phase, he has to undergo training.
So this is with regard to the submission with regard to the BEd training. And my dispute submission to this is, my lord, this is a fraudulent document prepared for the purpose he has undertaken his training.
Where do you get this fraudulent document? There's no finding of the single judge on
Yes,
that.
my lord. Yes.
So
So now kindly come to
fraudulent document and all.
Yes, kindly come to my appeal. And the next submission my friend has made. That the ground of termination was only, there are 2 termination order, what he said first. And secondly, ground of termination is untrained, not the contractor licensing. There are 6 charges served on him, and he has also given a reply to that. Kindly see the charges. He has admitted that charges. And sorry, he replied to the charges. Kindly see. Denied. How he is denying, what he is denying. Yeah. No.
Where did you hold the
page?
No, 1 minute. Did you hold an inquiry finding guilty of the charges?
I can't follow.
Did you hold an inquiry finding him guilty of the charges?
The charges, yes, we have given him. He has denied.
Please understand the question,
yes,
sir.
Yes. There.
Did you hold an inquiry finding him guilty of the charges?
As record says, there was no inquiry conducted.
Then why are you referring to the charges?
Charges because he has admitted.
Sir, where is the question of admitting a charge? He has only replied to the charge. He has not admitted the charge.
Kindly see the Annexure 9 series with regard to this contractor.
Sir, if you have not conducted an inquiry, where is the question of relying on charges?
Charges was, one of the charge was he was a registered.
You're making a case worse and worse.
No, my lord.
The more and more you refer charges for which you have not held an inquiry, the entire termination gets vitiated.
My response submission is it was not required for the reason the charge is, therefore I am referring to the charge first is a contractor. And the charge of contractorship, the documents we have confronted to him, he says no, but these are the undisputed documents. I deny all that.
Undisputed. He says no, and it is undisputed.
Documents are there, my lord, in the writ petition also.
Just listen to yourself, sir.
My lord.
We are listening to you. We find it odd. I think you're not listening to yourself.
My lord.
He says no. According to you, it is undisputed.
For the reason, my lord, the documents are there. Documents telltale. No further.
How do you use the word undisputed when a person says no? How do you use the word undisputed?
He says, yes, he says from his statement.
Anyway,
says,
it's all right.
Yes.
This is your way of arguing. Obviously.
No, he says,
yes.
I was a contractor, but I have not accepted any bills for that. And that is also the finding of the Honorable Single Judge.
All right.
And the judgment of the Honorable Supreme Court is if no useful, this is a futile purpose for us to go for an inquiry with regard to the contractorship. Since he has not disputed the fact, but rather it was admitted by him before the Honorable Single Judge, and Honorable Single Judge has come to a conclusion. Yes, he was a contractor, but he has not.
Your understanding is what is admitted, what is disputed is all your own understanding.
My
It's an amazing understanding. All I can say it's an amazing understanding.
My lord, kindly see the findings with regard to this contractorship, what the Honorable Court has held.
All right. When he's saying no.
Yes, I'm just placing it. Para 19, 243 page of the impugned judgment.
Right.
The director arrived at a conclusion, taking into consideration the document as provided by the managing committee by Annexure E/4. From Annexure E/4, it appears that there is no dispute that the petitioner was continuing as a C-class contractor at the relevant point of time. Those documents was before, again in appeal we succeed. He came into the High Court and High Court finding is this. The documents annexure E/4 also discloses that there has been some payment for petitioners undertaking work as a contractor, C-class contractor in the year 1986-87. Shall I continue? Yes. Here, I have used the word. I would have taken exception to that. No dispute.
We are amazed. Repeating, sir. We are not taking exception. We are just expressing our amazement of your understanding of what is disputed and what is admitted.
Yes. What I have stated is this is the finding of the honorable.
When somebody says,
he's challenging.
When somebody says A and the other person says no, according to you, it's admitted.
Admitted here in this says in context of paragraph 19 of this finding of the honorable signatories. I say.
All right, sir. All right.
He says the honorable court has said there is no dispute with regard to the petitioner because these documents were before the appellate authority.
All right.
And now kindly come to paragraph 22.
Right.
Here, my lord, the court has held the contradiction in the order of the honorable court. I will find out. This honorable court has document annexed review by 4. Again, I am reading 19. Honorable documents annexed review by there has been some payment for the petitioners undertaking work as a C-class contractor in the year 1986, again 93, 94, so and so. Kindly see paragraph 22. Further, from the document annexure E/4, it amply clear that petitioner was continuing as a C-class contractor even after such an allegation was made in the year 90. The documents at annexure E/4 has also been clear indication that petitioner not only continuing with the contractor license, but he is also getting some money through such contractor earning in the year 94 runs to 40,000 so and so in whole year. Similarly, the earning was earning through the contractorship in 94, 95 running from 50,000 so and so. This is also the position subsequently with the improvement in the financial side. So this is the Then, para 23. However, there are all receipts after termination of petitioner what are relevant to the appellant authorities to take into account the position of the petitioner as a contractor while notice of termination order was issued. Under the circumstances, I am the view that the director has also not appeared his mind in the above regard and is finding on the basis of receipt of the petition after minimum termination. After the termination order takes place, this is a finding error of fact from the record itself. What does the honorable court has says? He has received all this payment after the termination.
Today the school is up and running, is it? It's a new management.
Yes, management is there. Now,
no longer defunct.
Pardon? No
longer defunct.
Now it became added. The government officers are there and all these things. It is running. Right. There is no dispute over that.
All right.
So now the question is, now because now after the new rules, the headmaster becomes the secretary. Right. Headmaster in charge comes secretary. Ex officio. So now, therefore, the honorable court has said, here the contradiction in this case is, in paragraph 19, the honorable court has said, by looking into the record under annexure E/4 before the director, the lower court record, that payment has been received by him in 86, 87 onwards.
Right.
But here in para 24, the honorable court has said, all the payment were received after the termination. Termination was in 18,790.
Right.
This is a contradiction. Actually, the payment was in 86, therefore this finding is perverse. Not in accordance with the document which were before it. And so far, the two termination order, what is kindly see, my lord. What he has read, I have given the translated copies of all the documents I have filed. Odia annexures. I have given the translated copy on record. what my friend was reading to is 24(5). I have also filed it. Sorry, in his brief also he was referring to. I'm just referring to that 57. Yes, 66, 24,590. He says this is the first termination order. The second one is 18,790. My respected submission is 24,590 is a notice of termination, not an order of termination. It categorically stated that yes, there is a decision after all this process, and now we have decided, and you give your reply within that time. 1 month notice, last final notice was given to him, and termination order was issued to him on 18/7. So this cannot be said to be a term. There is two termination order. What he said is not a fact.
When did you deliver it to him?
Pardon, my lord? Yes, he has received it, my lord. There is no dispute with it. Delivered on. That I am giving. Date. But I have to verify the voluminous document because I cannot give. There is a delivery because these are not the issues before the court. Therefore, I am not ready on that respect. But it is
we
there.
wanted to know.
All the records are there.
We want to know that.
My lord, yes, I will. If my lord will give some time, I will verify and verify.
1991 I received that letter.
That he is saying. That is not a fact. Registered portrait. And he has SL that termination order before the director in the appeal. And the order of the director is Annex 13. Alicia.
All right. Orders reserved. Yes, caller takes back.
I have something to say. I am appealing for respondent number 5. I am continuing since 1992. I am a trained person and duly selected. Because of this litigation, I am not getting my salaries, my lord. But earlier, this present appellant filed a writ application challenging the first notice, stating it to be a notice for termination. In that case, he made another person as party. He made Purnachandra Naik as party. But in appeal also, I was not made party. In the replication filed challenging the order of the director, I was initially not made party. Subsequently, I was implemented. But in such circumstances, that Purnachandra Naik against who was appointed against the termination vacancy of the appellant. As per his statement, he was appointed. But I am the second trained graduate teacher. But since 30 years, I am rendering service. But because of the situation, I am not able to get my salary.
All
that is what I have got to say, my lord.
All right.
I have also filed counter affidavit, my lord.
All right.
Press admission item number 1, STREB 51 of 2013.
Your Lordship, here the question of law is at page 21. This is also covered. Whether the circumstance of the case, the tribunal acted with the material illegality and beyond the scope and authority of Finance Department notification, bearing number so and so 31st March 2001. In this case, Your Lordship, the notification is the same notification has been challenged and the same question of law as question of law number 1 in this order. State of Orissa versus Guinea Metal Industries Private Limited. Also,
as the
same
opposite party been served.
13 case also the same issue has been decided.
So since the question of law is being answered in that case, no need to answer it in every case, sir.
Your Lordship, this is
because they've not even been served in all these 8 years.
Your Lordship, in this case, Your Lordship has stated that since it has been decided in Guinea Metal, so this is covered. in this case.
Yeah, but without notice to the respondent. For 8 years, there's no notice to the respondent. There, despite service, none appeared. Here, there's not even notice. You say the questions raised in the present petition already stand answered in STREV 136 of 2011 by the judgment dated 19 July 2022. Consequently, the court is not inclined to again entertain the present revision petition only for that purpose. The STREV is disposed of. Right. Item number 2.
2 is 9,080 euros.
Tax effect.
Your Lordship.
Tax effect being 9,080 and insignificant, the court is not inclined to entertain the STREV when it is disposed of as such. Item number 3.
Your Lordship, item 1. Item 1, Your Lordship, I think notice has been issued, Your Lordship, dispensing, Your Lordship, on dated 2nd 12 2015.
Let's see that.
The order dated, Your Lordship, what my record says. Your
No. Only the miscase was
2nd
disposed
December
of.
2000.
You can show the orders. Kindly see the orders. It's all right, sir. Judges are always wrong. We are in a hurry. We mistakes. We don't read properly. No, kindly see. No problem, sir. If you have a doubt, it should be discussed.
No, Your Lordship.
No, kindly read it. No, please show it. Please read it, satisfy yourself.
Your Lordship.
No. Please.
This is an application for Your Lordship, 100 and council for acceptance. The miscase is disposed of. Only dispensing as well. Then, Your Lordship, item number 3 is also the same dispensing. What I think Your Lordship can verify the record, Your Lordship. 15/9/2015, only dispensing been done, I think.
Yeah.
Can I argue, Your Lordship?
No. What is item 4? 3.
Your Lordship.
What were you saying?
No, Lordship, what I think the same, the only dispensing has been done. Notice has not been.
Yeah, notice is not gone.
Your Lordship.
No, what is it covered or not covered or what is it?
Your Lordship, in this case, it is not covered. It is to be argued, Your Lordship.
Tell us what it is.
Your Lordship, the question of law is at page 10. 10 and 11. Your Lordship, the Law and Tribunal has stated that it is an interstate sale. But you'll have interstate sale. But Your Lordship, there is a violation of 6.2. Section 3, section 6.2, Your Lordship, since no statutory forms have been submitted, Your Lordship. So in absence of statutory forms, Your Lordship, the CST sale cannot be justified, Your Lordship. So that it has been stated that it is interstate sale. And the sales and the assessing officer at page 20, page 6, internal page 6 and running till 20.
This is the one you located. All right. List before a bench of which Justice Raman is not a member. In the usual course. Item number 4.
4 and 5. It is.
All right. Item number 4. All right.
Item number 4 and 5, Your Lordship, it is the same. Notice has not been issued. And also it is covered against the revenue.
By what judgment, sir?
Your Lordship, so far as that AVR, headed by Assistant Commissioner against the revenue.
All right. The questions urged in these 2 revision petitions stand answered against the revenue by the judgment dated 13 July 2022 of this court. in STREV 117 of 2013. Accordingly, these STREVs are dismissed.
Item number 4 and 5.
Yes, please.
Item number 6.
Item number 6, Your Lordship, it is identical matter. It is identical matter so far as the 2J is concerned. Your Lordship might have remembered all those 2J matters have been fixed on 5th December. Your
All right,
Lordship.
list on 5th December. All right.
Your Lordship. Okay.
Item number 7.
May. Here, my lord, it is ex parte order of the assessment, ex parte order passed by the tribunal. And the issue is not, the question is not, I've referred in paragraph is running page 5.
What's the tax effect?
Tax effect is not a small dealer, my lord, including penalty of 3,31,000. So
Why not they would have recorded from him?
You have deposited, my lord, as per the order of the commissioner during the pendency of the 1 lakh something I have paid, my lord.
Oh.
Now the question here is, my lord, the fact remains the vigilance was conducted, my lord. In the inquiry, they have detected an audit report of a farm. And in farm, there is an opening stop of purchase. And some my lord, check of issued to somebody else. that has been stated to be a suppression and impose tax by adding 20% of sale value and determining the tax and penalty. And these honorable court, my lord, held.
This ex parte order by the tribunal can go back, sir. On that short ground, let it go back.
Your Lordship, to the tribunal.
The impugned order of the tribunal is an ex parte one. On that short ground, the court sets aside the impugned order of the tribunal and remands SA number 74-ET of 2012-13 to the tribunal for a fresh determination in accordance with law. The parties will appear before the tribunal for the above purpose on 19th December 2022. The tribunal will then proceed on merits and endeavor to dispose of the appeal as expeditiously as possible. The deposit already made by the
order of the commissioner during pendency of the second
petitioner during the pendency of the present petition.
Second appeal.
Second appeal will continue and abide by the final decision of the tribunal. The STRE is disposed of in the above terms. A copy of this order be sent forthwith to the tribunal.
Much.
Item number 8.
Yeah, the tax effect is 21,000.
None appears dismissed.
Item number 9.
Same order.
Item number 10.
Same order.
Item number 11.
Your Lordship, it is identical so far as the first case.
First case.
Item 1.
The present revision petition is disposed of in terms of the order passed by this court.
My lordship may refer to that STRV 69 by 2009.
STRV number 136 of 2011.
On 19 July 2022 in STREV 136 of 2011. Bracket State of Odisha versus Ginny Metal Industries Private Limited. All right.
Okay.
Item number 12.
My lords, this is audit assessment. There was no assessment at all. And they have not complied, they have not served us the audit visit report. And your lordship, without original assessment, this audit assessment is not valid.
So it's covered by
ECMAS.
No, audit assessment, it is 42 assessment.
It is not reassessment, it is audit assessment.
It is audit assessment.
My lord.
Your Lordship, tribunals of...
My lords, kindly see the assessment order. They have not served us the audit visit report. My lords, kindly see page 14, the assessment order. Audit visit report was not served or not.
It's confronted to the dealer.
My lords, confront will not suffice the requirement.
You have a judgment. You have a judgment in your favor.
My lord. Along with the notice, my lord. Statutory notice. E30 notice.
I don't know. Is there a judgment in your favor? Is there a decision in your favor, sir?
My lord's E30, my lord's form says that.
Sir, kindly understand the question I'm trying to ask, sir.
I'll get it, my lords. I have not, in that line, I have not investigated.
All right, at the request of, just remain on board there.
It is prior to amendment. Prior to amendment, only confrontation can be done. Prior to amendment.
You better get the original record, you will know whether it was served on him or not.
Item 13. 13, my lords, maybe taken up, I missed the file.
All right, stay on board.
Item number 14.
My lord, question of law is, my lord, at page 7, my lord. Whether.
What's the tax effect, sir?
My lord, tax effect is 13 lakhs 33,567.
You must have deposited that amount by now?
By now, he has paid all the tax.
All right.
Question of law is not admitted till date, never listed here.
That's right, that's right.
My lord, questions of law is at page 7, my lord.
Yes.
Paragraph C, my lord.
Yes.
Whether MS rod used for foundation, my lord, of the plant can be treated as capital goods in terms of section 2(8) of the OVAT Act. Then, my lord, para E, my lord, capital E. Whether tribunal is justified in upholding the levy of interest which was imposed under section 34(1)(c) of the OVAT Act, particularly where the aforesaid provisions of law to failure on the part of a dealer to furnish return, revise return, or final return. Your losses may actually he has disallowed the ITC in respect of MS rod used in the foundation of the plant, my lord. My lord, then the first appellate authority allowed 50%. Since the MS rod were used in the foundation of the plant, the first appellate authority allowed 50%, but the tribunal reversed the judgment. Your losses may kindly come to page 20, first appellate order, my lord.
No. These questions have not been decided earlier either by this court or any court.
No, my lord. Your losses.
All right. Notice confined to prayers C, questions C and E.
My lord,
at para 7 of the
question C and E, my lord.
What, yeah.
My lord.
Right. List in the miscellaneous board on 27th February.
Item number 15.
Deeply obliged, my lord.
None appears dismissed.
Item 16.
Same order.
Item 17.
None appears dismissed.
Item number 18.
Not placed, my lords. It is not pressed, my lords.
Not pressed. Dismisses not pressed.
Item number 19.
Now, you see, the question of law is at page 15, my lords.
50.
15, my lords.
What's the tax effect, sir?
Tax effect is 2,93,000. The question of law, I'm reading, my lords. First question is
penalty, both are penalty.
Penalty, my lord. Well, this issue is also covered. Let me just place the question on. Whether in the facts and circumstances of the case, the division bench of the Orissa Sales Tax Tribunal was justified in upholding the imposition of penalty under section 10D of the CST Act, while holding that the petitioner was served with a show cause notice under section 10B of the CST Act and not under section 10D of the CST Act. Well, may I kindly see the provision of this CST Act?
No, it's not been decided.
No, my lords.
All right, notice, he accepts notice.
My lords, this is a covered case, my lord. Just
he'll have to examine it anyway. Show us the decision.
Yes, ma'am. Well, my humble submission is that if a notice is issued under section 10B,
then order cannot be passed under section 10D, my lords, because the 10A penalty being a quasi-criminal proceeding. My lords, may kindly turn to last page, para 12. I'm reading, my lords. The fourth line from para 12, fourth line, 4th to 5th line. If there is anything in the mind of the authority, my lordship got it?
Yes, yes.
In issuing the show cause notice, the same should be translated in clear words and must find place in the notice so that to enable an affected person, dealer, to whom the exact allegation raised against him on the basis of which he will give his reply.
So basically, this judgment, Mr. Mishra, says that if you issue notice under 10B, you can't impose penalty under 10D.
Annexure, the notice.
Should we allow it then?
Your Lordship, just one occasion for examination. As your Lordship pleases. I'll have not to you. As your Lordship
Can you see the notice, show cause notice, annexure 1?
All right.
No, that is in the question of law. That is not.
Just say admit the following question of law is framed. Take question 1 from page
1515.
15. When you say counsel of the petitioner states that the above question is answered in favor of the petitioner by the judgment in Southeastern Coalfields Limited versus sales tax officer. This Manu Patra decision, citation you can say. Mr. Mishra states that he may be granted a short adjournment to examine the decision. List on 27 February in the miscellaneous board.
Item note 20. Item 20.
Your Lordship. Sorry. Your Lordship, the question is at page 16.
Yes.
Whether the fact justified in confirm whereby purchase of paddy by the opposite part dealer from cultivators unlisted dealer was to be eligible to tax under section 3B of Orissa Sales Tax Act, notwithstanding the fact that sale of rice procured out of such paddy has been sold to exporter in order to comply with purchase order placed by foreign buyers, was exempted by virtue of section 5(3) of Central Sales Tax Act. Therefore, the order of the Learned Sales Tax Tribunal, Your Lordship, in the is untenable in the eyes of law. Your Lordship may kindly turn to the tribunal's order.
What's the tax effect here?
Your Lordship, the tax effect is, I think, more, Your Lordship, 3,82,000. Tribunal's order at page 44.
Assessment of 98-99, sir.
Your Lordship, at page 47. Paragraph 18, Your Lordship. The Line Tribunal is allowed, but the assessment order, Your Lordship, I can see at page 23. The assessment order at page 23. The forum is now is to decide whether purchase tax under section 3B of the OST Act is leviable on the purchase turnover. A paddy out of which rice has been obtained and sold to exporter who was in turn exported the same to the outside India as claimed. Your Lordship, that has been examined by the Learned Sales Tax Officer, and Your Lordship can directly turn to page 24, the next page. In the present case, admittedly, 3 transactions are involved. Namely, transaction of sale and purchase between cultivator, unregistered dealer, and the assessee. In other words, selling of paddy by the cultivator to the rice miller and purchase of paddy by rice miller from cultivators is the first transaction making for the first incidence of taxation of purchase tax. And second is transaction of sale and purchase between the assessee and the exporter. In other words, sale of rice, Your Lordship. Then third is the transaction of sale by the exporter to the foreign buyer is the third transaction which is not taxable. So first 2 transactions, you will see third transaction is not taxable. So this simple question which arises in this case is point of which tax is to be levied. The dealer has purchased paddy as the first purchaser in Orissa and sold rice after milling the same paddy, either Orissa or in the course of export. A bare reading of subsection 3 of section 5 of the CST Act, it is clear that said provision only the last sale or purchase immediately preceding.
There's no judgment on this.
Your Lordship,
No, you want to examine it or not? That's all I'm asking.
past transaction cannot be exempted, Your Lordship.
All right, notice returnable 27th February.
Item 21.
Get clear.
May I be permitted to please this matter minutes? But here this deals with the penalty, imposition of penalty. The Lordship would kindly turn to page 7, the questions of law. Relevant would be B, whether the tribunal is justified in upholding the levy of penalty under section 9C5 of the OET Act by invoking subsection 5 of section 33 of the OVAT Act, which restricts the acceptance of voluntary disclosure after receipt of notice of the audit, the tax audit, particularly when similar provisions has not been enacted under the OET Act. And E would also be relevant, Lords. Whether
What's
penalty,
the amount involved?
Penalty, my lord, is 7,59,232.
All right.
Your Lordship, covered by Your Lordship judgment. Your Lordship might have remembered that 42.
Please. This, I'm not questioning whether they have the power under 42.5 or 9C5, my lords. The question, my lord, is here there is admittedly a payment of tax during the course of the audit. So if your Lordship can permit me to place 33.5, my lords. 33.
Let notice go. Say notice confined to questions B and E.
So this is a
at page
B and E.
Yeah, of at para B of at internal page 7, para 9 at internal page 7.
And right. E also.
Yeah, B and E. 28th March.
Item number 22.
Your Lordship, here the 77,000.
No notice is gone. How is it in the final hearing list? Many of these matters, no notice is gone. Yes, No. No. How is it a weekly list, sir? I don't understand. No. What is the principle of a running weekly list? Fresh matters will come into running weekly list. Yeah. That is the Orissa tradition, is it? And I've never come across this in any other high court, sir. You think it is correct? That is something will not be admitted for 10 years and given in the weekly list. No. What are you trying to say?
No, bar comes. Something which has not come to fresh admission for a longer period. In the weekly list, if it is kept in the fresh admission list,
you'd be obliged, Milords. So instead of having a weekly list throughout the week, Milords, if a Lordship can batch wise bring it.
No, he says this is the correct thing to do.
Okay. No, my lord says if fresh admission matters are put in weekly list, is it proper or it is the practice here?
Here, Milords, normally it comes in the regular list. Because this long list is usually reserved for hearing matters.
That's what I thought.
So it's not
in all high courts. That's what happens.
First, they have to be admitted, then heard.
That's what.
So
this is very strange. I've never come across in any other high court. This is my third high court.
Our practice,
unless something is admitted, it doesn't go into a final hearing list.
No.
This is the first time I'm coming across a fresh matter which has never been listed even once in a final hearing list.
Yes. In our High Court also, my lord, the trend was it was first Lord, listed for admission. So if your lordship is satisfied on the question of law, your lordship may dismiss it on that.
That's what.
Or if your lordship would admit it, then it comes to the hearing.
Correct. What my lord said, that was going on previously. Yes.
That
So
was
I
the
don't know
system.
how. That was the
Anyway, some cases, my lord, issue notice thereafter without admission, it is listing the final list.
Yes.
All others are fresh items. So they should have been in the main list.
Fresh.
Including orders also.
In this list also, the heading is fresh admission.
Yes.
Fresh admission and orders.
Very strange. I think we'll have to instruct them properly.
Maybe, my lord,
Weekly list has to be only matters which are already admitted.
in fact, it had to begin from the seed 90.
All other matters will go into the miscellaneous, whatever, the hearing list.
In fact, your lordship's list should begin with item number 90.
That's what he's now telling me that. It's good we took it up today. I would have never realized. Otherwise, it will be languishing.
No, that was always the practice of this honorable court.
Understanding in the other high courts is unless a matter is admitted, it never goes to a final hearing list.
No, final hearing list. So that was a practice also in our honorable court.
All right.
Maybe because the matters are old, that's why.
I have forgotten. All right. Can call it.
Item 22, sir. Item 22.
Let's see, 77,000.
All right. The tax effect being insignificant, the court is not inclined to entertain the STR even, which is supposed of.
Item number 23.
23, let's see, the question of law is covered by the judgment of Honorable Supreme Court.
Okay.
Your Lordship may kindly turn to page 16. This is the Bajaj Auto case. Surcharge, your Lordship, levy of surcharge. Your Lordship, question 2. Honorable Supreme Court is in session of issue involved in matter Commission of Commercial Taxes versus Bajaj Auto. In the meantime, that order, the order of Honorable High Court has been reversed by Honorable Supreme Court.
Correct.
Your Lordship, so that judgment is applicable. So the entire order of the tribunal is as per the judgment of this Honorable High Court, which has been reversed.
So we'll have to issue notice. Notice returnable. 28th March in the miscellaneous border.
Item number 24.
May it please your Lordship, this is the individual and composite contract, and the contract is continuing. The specific question I have asked before Lordship at page 9. Whether or not under the facts and circumstances of the case, the division bench of the tribunal was justified.
What's the tax effect, sir?
Tax of 2 lakh, more than 3 lakh, about 3 lakhs. 2,69,000, something more than.
So which question are you pressing?
Question number 1, my lord. Because
notice
division bench of the
confined to question number 1 at page 9. He accepts notice.
in this case, division bench number 1 and the full bench accepted the
16th March. 16th March.
10th March.
16th March.
16th March.
Item 25.
25, your Lordship, 873.
There's a delay of 873 days in preferring this STR. With the delay not being adequately explained, the court is not inclined to conduct the delay. The STR is dismissed.
For order item 6.
Not pressed.
Not pressed.
This is covered.
It's not removed because of that.
Item 27.
None appears dismissed.
Item 28.
Same order.
Item number 29.
Your Lordship, that is 45 and 1515.
In view of the insignificant tax amount, the court is not inclined to.
Next item 30 is 18,000.
Open for decision some other.
8,315.
Same in 30. All right.
Item 31.
May I please? My lord, I have removed the defect. Last 2 defect is not required because it is a sales tax revision. Prayer is not required. And I have given the annex question of law. So provision of law.
What's the tax effect, sir?
Sir,
1,45,000.
Want to
This is
pursue all this, sir?
covered by your judgment, your lordship, since it is on the credit notes. During the warranty period, I have exchanged the spare parts and receiving the credit notes. Based on the Supreme Court judgment, it was levied. Now the matter is referred to the larger bench.
Ikram Khan has been referred to larger bench.
All right. It is stated that the question raised here is awaiting the judgment of the Supreme Court of India in Tata Motors Limited versus Deputy Commissioner of Commercial Taxes, bracket, order dated 5th February 2019 in civil appeal number 1822 of 2007. Paragraph. Awaiting the judgment of the Supreme Court list, along with STREV 54 of 2009, after the judgment of the Supreme Court.
Item number 32.
Your Lordship also decided in the case, my Lawrence Senior also argued, I have remembered that case, whether he is a dealer or not, whether central government is a dealer. Your Lordship has decided in one case. Since I have not received the copy, I could not tell what is the issue.
Actually, I got the copy from the LMS system. Below the tax better. I give you copy.
Just but 29,000, so no need to entertain it. The tax effect being very minimal. The court is not inclined to interfere. The question urged is left open for decision some other class.
Item number 33.
May it please, Milords. First, this is
may one thing, because the government of India is coming, so let's may observe one line that this decision may be binding for other because so many cases are coming.
When we say left open, that's what it means.
May it please, Milords.
What's the delay?
Milords, this petitioner is a proprietorship concern engaged in the fabrication unit of almirahs and steel racks.
204 days delay.
Your Lordship, condemnation of delay also.
There's not a delay of 204 days in preferring the STREV, which has not been properly explained. Consequently, MC number 48 of 21 is dismissed. The question of law is left open for decision some other properties.
Grateful.
The STREV is dismissed.
Item 34.
Your Lordship, 315 days delay.
Same order here. Yeah.
Item 35.
35 also 315 days delay, 83,899.
Same. Yeah.
Item 36.
36, Your Lordship. Lordship, item 36. The question of law is at page 19, Your Lordship. Whether on the facts and circumstances the tribunal aid in affirming the view of the First Appellate Authority while allowing the claim of concessional rate of entity tax under Rule 4 of Odisha Entity Tax Rule 1999 by the dealer treating chemical as raw material, Your Lordship, and whether the facts and in the tribunal error in holding the order first appeal wherein the claim setup of entity tax paid on raw material which did not go into the composition of finished product against the sale of finished product has been allowed by reversing the finding of the assessing authority, Your Lordship. Your Lordship, again this raw material issue, Your Lordship, that setup of entity tax and paid of raw material, whether those material are raw material or not, it is to be. So, Your Lordship, let notice go. So far as the packing material, also a question of law, which Your Lordship has already decided that has not been taken. Your Lordship, some amendment question of law is required. And also, Your Lordship may admit the question of law because that question of law is also pending before under the Supreme Court. Whether raw material under Entity Tax Act or not, Your Lordship. So,
it's a notice returnable 28th March in the regular report. Okay.
Item 37.
None appears dismissed.
Item 38.
38, Your Lordship. 38, Your Lordship, it is advance ruling. Sorry. Your Lordship may kindly turn to the question of law, page 10. Whether in the facts and circumstances the tribunal is justified in quashing the order of the authorities below on the ground that assessment claim under section 43 of Odisha Value-Added Tax Act is barred by limitation in view of stipulation contained in section 42 of the said act, Your Lordship. Your Lordship may kindly turn to the tribunal's order. Your Lordship, 42 limitation is something different. 43 limitation is something different, Your Lordship. 43, a period of completion is there, 3 years, 5 years, 7 years. And 42 after the, within 6 months, after completion of the assessment. Your Lordship may kindly turn to the page 26.
27, sir.
Your Lordship. Here, Your Lordship, the assessment has been done under section 43. But enter tribunal's order as if the assessment has been completed under section 42. 42.6, 42.7, Your Lordship, everything has been taken.
Because it's pursuant to an audit visit report.
Your Lordship.
You have to invoke the right provision, sir. If it's pursuant to an audit visit, you have to.
No, Your Lordship. Your Lordship, it is the assessment. Also, Your Lordship, if I'll argue otherwise, then it will go to against the revenue. So far as the last para is concerned. Your Lordship, but here the fact remains, Your Lordship, at page 14, 1.4. The assessment has been completed under section 43, not audit assessment.
No, but your whole discussion is on the audit visit report only, even in your assessment order.
No, Your Lordship.
Yes.
No, Your Lordship. Your Lordship, at page 1.4, 14. So that is the wrong committed, that is the inadvertent mistake committed by the learned tribunal. Your Lordship, here, as per the report of the farm, as per the report, the farm was visited on 11/7/2007 by a team of officials of Ganjam, where the team of the leader was STO audit. At the time of the visit,
it is only on this basis the assessment is complete, sir. What are you trying to say?
Your Lordship, enter order, in all the orders, it has been stated that assessment has been completed 43 and first appeal.
Maybe
40.
that doesn't make it right. If the whole assessment is on this report of the audit team, it had to be under 42.
Auditing, investigation audit. It is not the statutory audit team. Or if audit team could have the assessment could have basing on the audit report, then the assessment is to be under section 42, not under section 43, Your Lordship.
That's right. So that's why he's challenging it.
Then nothing is to be decided.
Para 8.
I have already submitted that it is against the revenue.
It will not affect in any either way.
Your Lordship, I have already stated that.
You say it is the order of the tribunal that section 43 bracket 1 should be invoked only if the dealer is initially assessed under section 39, 40, 42 or 44 of the Orissa Value Added Tax Act 2004 bracket OVAT Act. The issue already stands decided on this aspect against the revenue, against the department in Keshav Automobiles versus State of Odisha with the citation. In that view of the matter, the court is not inclined to entertain the present STREV and it is dismissed as such.
Item 39.
None appeals dismissed.
Item number 40.
Your Lordship, item number 40, 41, 42. Your Lordship may kindly look into the cause list.
Yes.
Your Lordship, if Your Lordship will...
No steps have been taken. You said despite notice, steps have not been taken for service of notice on the sole respondent. In that view of the matter, the petitions are dismissed for non-prosecution.
40 and 41.
And 42. 40, 41, 42. 41, 41.
Item 42.
Your Lordship,
defect not removed. You said despite 8 years, defects have not been removed. Dismissed for non-prosecution.
Item 43.
43, Your Lordship, 94,688. Is that also?
My Lord, I am respondent. 3 items.
What's the delay?
Only 7 days delay.
What's the question, urged, sir?
Only 7 days delay, Your Lordship. A question applies at page 7. The reasons contained therein are indicative of non-application and misconstruction of provision contained in the statute as such the same is liable to be passed. And the order 10 for your lordship may kindly turn to the tribunal's order page 35.
94,000, sir.
My lord.
94,000.
Your lordship.
The tax effect being insignificant, the court is not inclined to entertain the present STR. It is dismissed as such.
Item 44.
For my lord, the tax effect is 75,000.
The tax effect being minimal. The court is not inclined to entertain the present STRV. The question of law is left open for decision in some other properties.
Item 46.
46, your lordship. Your lordship may kindly turn to the question of law at page 13.
What's the tax effect here, sir?
Tax effect, my lord.
Must be quite substantial. All right, you say notice returnable. February 27th. In the miscellaneous book.
Item 47.
My question of law is at page 6, my lord. Here,
25,000.
My lord, the penalty imposed by the assessing authority and first appeal, but enhanced by the tribunal without valid reason, my lord.
What has it been enhanced to, sir?
Without that, it is mandatory. Well, but the provision is not mandatory, my lord.
It's all right. 25,000 we are not going to entertain. Since the penalty amount involved is only rupees 25,000, the court is not inclined to entertain the present STRV, leaving the questions of law open for decision in some other appropriate case. The petition is dismissed.
Item 48.
48, there's in this case for dispensing with Annexure 1 and 2 minutes.
Sorry?
In this case for dispensing with Annexure 1 and 2, is the assessment order and the first appellate order. Here, my lords, if your lordship would kindly turn to the tribunal's order, in my humble submission, my lord, there's no application of mine, my lord. Tribunal order at page 27, if your lordship would say.
But this is not, notice is not gone in this.
Notice has not gone.
All right, notice, he accepts notice. List on 2nd March.
Item 49.
None appears dismissed.
Item number 50.
None appears dismissed.
Item 51.
Same order.
Item 52.
51, your lordship is covered by.
51.
Yes, your lordship. 51 is covered, your lordship, by the judgment of Keshav Automobiles. Question of law free. Question number 1, your lordship.
All right. You say admit the following question is framed for consideration. Question number 1. Question A.
In the reframe question of law.
9. Yeah. Question A, page A. 9. Question A. In view of the judgment of this court in Keshav, the said question is answered in favor of the SSC and against the department. The impugned order of the tribunal is accordingly set aside. The revision petition is allowed. All right.
Item 52.
52 does in this case for dispensing with annexures 1 and 2 minutes. There's the assessment order and the first order minutes.
That MC is allowed.
Question of law, my lord, is if a
all right. Notice returnable 2nd March.
Item 53.
The MC is allowed.
53, your lordship. Your lordship, it is covered. It is covered by your lordship judgment that caterpillar.
Covered against the revenue.
Against the revenue.
The questions urged in the present revision petition stand covered against the revenue by the decision dated 2nd August 2022 of this court in STRE number 31 of 2011. State of Orissa versus Geeta Shri Industries. In that view of the matter, the STRE. All right.
Item 54.
Your Lordship, 58,657.
Tax effect. Due in view of the insignificant tax effect, the STRE is not entertained, leaving the question of law open for decision some other appropriate case.
Item 55.
Your Lordship, 55 may be admitted.
Delay.
The question of law here is that 2 days delay, Your Lordship.
The delay is condoned. It's already admitted, is it?
Question of law, only dispensing has been done, Your Lordship.
All right.
Vinyl flooring would fall within the scope of plastic so as to levy with sales tax at the rate of 8% under NT 136 of the list of the goods.
There's no judgment.
No, Your Lordship.
All right. What's the tax effect?
Tax effect, Your Lordship, more. 1,46,310.
All right. Notice returnable 14 March. All right.
Item number 56.
Item 56, Your Lordship, 36,220.
In view of the insignificant tax effect.
Item 57.
57, Your Lordship. Let me argue the matter, it is covered. Whether it is Wascon, Your Lordship may kindly turn to page 11. Whether in the facts and circumstances of the case, will fail in error in treating the contract of artwork in formation involving clearing of ground, stacking of art from railway land, supply of art by contractor from other sources, supply of morum, and spreading it over the art formation and mechanical compaction as was contract.
What's the tax effect?
It has been decided. If the tax effect is more.
All right, you say notice returnable
4,39,000.
Much.
Item 58.
My lord, in item 58, the tax effect is 1 crore 30 lakhs. And Your Lordship, the question of law is framed at page 15.
The date of receipt of the impugned order is not filed, sir.
Your Lordship, it was not there, but we have given it on at page 61 that it was received on 22nd of January, my lord.
But you have to show some proof of that.
Lordship, I will file, if Your Lordship will give me some time, I can file the proof. It is within limitation.
You say notice subject to the limitation being addressed at the time of admission. He accepts notice list on 16th March.
Item 59.
Your Lordship, item number 59, the same identical matter, Your Lordship, so far as the 2J, constitutional validity of section 2J, also in this petitioner's case also, are fixed on 5th December.
Or it's list on 5th.
Item 60.
60, Your Lordship, 69,900.
In view of the insignificant tax effect, 60 is dismissed.
That's my
61.
Great. Lordship, in 61, the tax effect is almost around 48 lakhs, my lord.
61, I am appearing.
Lordship, I'm sorry.
But your Lordship may kindly just turn to page 36. It's a covered matter. Your Lordship may.
What happened to that 500 rupees you have to pay?
It's paid, my lord. My instructions are it has been paid, my lord, to the bar council. It's
covered in favor of the SSC.
You are covered in favor of the SSC, my lord. I am giving the judgment in Kripal alloys, my lord. Here there's a delay of more than 3 for service of the assessment.
All right. It's a notice returnable.
No. The date chart, if your Lordship would appreciate, I've given the.
This is the first time it's coming up.
Sorry.
Notice is not gone in this. Notice returnable 70.
Lord, should we keep that?
22nd March.
22nd March.
Item 62.
You have to unmute yourself, Mr. Mantri.
Lordship, at page 75, the order was issued on 3/2/2014, and I have at page 9, I have averred that it was received on 24/2/2014.
Anyway, subject to showing proof of, subject to satisfying the court about limitation. Notice, he accepts notice. 22nd March.
Lordship.
Item 63.
Here, delay, my lord. In the questionable at page 6, my lord. Whether in the first and second case the tribunal is legally correct to direct the determination of tax rate at the rate 4% in case of interstate transaction of payments made against the declaration from D and 1% against declaration
Delays
from
condone, notice returnable 22nd March.
Item 64.
Please, sir. I have removed the defects. The 13 days, there is a delay of 13 days.
Delays condone. Yes.
And this impugn has been revised with the larger bench of the tribunal in my favor. I'm giving the copy. Here, the explosive was not in the scheduled goods. Till 25
What is the
February.
tax effect, sir?
This has been now decided in the larger bench.
What is the tax effect?
4,93,000.
Or notice returnable 23rd March.
Item 65.
Your Lordship can
What's the tax effect, sir?
Your Lordship, here tax effect is 18 lakhs. Your Lordship, but it is only wanting of statutory forms. Since statutory forms has not been provided, so demand has been raised.
No, it's something else. The questions are at page 13.
Your Lordship?
This is STRE 116, right?
1 and 2.
Oh, 112. Sorry,
112.
sorry. 65.
112 question applies at page 5. Whether in view of certain disallowance of interstate sale for wanting of C form was just and proper. Your Lordship, statute says that you have to produce C form. And in absence of that, whether it is justified, Your Lordship, I don't know.
So, issue notice.
Tribunals.
Or it delays condoned, notice returnable. Oh, none appears.
None appears.
Dismissed.
Item 66.
66, Your Lordship, 9,720.
The tax effect being insignificant, the court is not inclined to or delay of 261 days is also not explained. Dismissed on both grounds.
67.
My lord, 67, I have no instructions here.
No instructions.
Item 68.
68, my lord, so this is audit assessment without supplying.
Without supplying copy also to me.
So it has to be allowed. Deficit court fee not paid, sir.
My lords, I will remove the deal within 2 days.
All right. Counsel for the petitioner undertakes to remove the defect within 2 days. List thereafter in the miscellaneous board.
Item 70.
None appears dismissed.
Item 71.
My lords, 71.
What's the tax effect?
It is audit assessment without any audit, my lords. There was no audit. There is no audit budget report, and it was made audit assessment.
All right. Notice returnable. 28th March. He accepts notice.
Item 72.
72, my lord, I'm appearing. This is a similar matter has been kept on 28th of March, my lord. It is
Delay is condoned. Notice returnable 28th March.
Item 73.
73, Your Lordship, 42,860.
In view of the insignificant tax effect. The STRA is dismissed.
Item 74.
Here in this case, what has happened in the immediate preceding year, 82% was accepted as a service component by the same officer. In this year, it has been at 70%.
11 months delay, Your Lordship.
Let's see. The issue is very much covered. The tribunal says that rule of consistency has no application in tax laws.
All right.
That's the
right in some other year. The delay is unexplained. MC is dismissed. Consequently, the STR is dismissed. The question of law is left open for decision in some other probabilities.
As a tax effect is quite high. It's 2.2 lakhs.
It's all right. Nothing. These days, that's nothing, sir.
Grateful.
All right.
Item 75.
Dismissed.
Item number 76.
None appears dismissed.
Item 77.
Miller 77. MC for dispensing with of Annex 2 and 3. Assessment order and appellate order, and your lordship may kindly see the questions of law at page 7, my lord. Capital B, my lord, paragraph. Whether the tribunal is justified in confirming levy of tax at the rate of 4% on the
this cattle feed and all, we already decided, no?
My lord, that disputed amount is 1,94,000.
In your favor.
Kamadhenu cattle feed or something, no?
Cattle feed is exempted, my lord.
In your favor.
All right. Admit the following question is framed for consideration. Just question B.
B, my lord, D. Lordships kindly B and D.
B and E.
D, my lord, D and D. D.
Both the questions stand answered in favor of the SSC and against the revenue by the judgment of this court in. So we've just answered that question. Cattle feed. Where's the decision?
Jagajanan. Just now we passed on that Gita Sri Industry.
Gita Sri is that, no?
Gita
Sri. In state of Orissa versus Gita Sri Industries. Correct. Bracket decision dated 2nd August 2022 in STREB 31 of 2011. Accordingly, the impugn order of the tribunal is set aside. The STREB is allowed. All right.
Obligement.
For admission, item 78.
78 means no instruction.
No instructions dismissed.
Okay.
Item 79.
See, my other grievances.
Your Lordship.
The petition is dismissed with liberty to the state to revise as and when the file is traced. Yes.
Item 80.
Free for some other day.
Your Lordship, item number 80. Your Lordship, item number 80 can be disposed of with the consent of my learned senior. It is for the assessment year 97-98. 98-99, Your Lordship, this Honorable Court has passed the order. And the petitioner has withdrawn that STREB. Why, Your Lordship? Because in the first appellate authority has set aside the matter, remanded the matter for fresh assessment, Your Lordship.
Let it come.
Or it will stay on board.
Let it stay on board.
Your Lordship, item 81. Your Lordship, item number 81, supply of ballast, that is covered, Your Lordship. I have to argue. Your Lordship, the question of law is at page 13, Your Lordship. Whether the facts and circumstances of the case, Odisha Sales Tax Tribunal failed in error in treating supply, stocking and spreading of ballast by the opposite party as was conducted. It is covered by two of the judges. Your Lordship.
Against the revenue?
No, in favor of the revenue. It is to be was conducted.
Notice returnable 28 March.
From 82.
82, there is delay of up to 71 days due to ill health.
71 days.
71 days, maybe. In this case, para 2, my lord. 2 and 3. This case number 146.
What's the tax effect, sir?
More than 5 lakhs, my lord.
Here it is the anti-tax, admitted tax has not been paid.
The question,
Your Lordship,
my lord, here the question is, my lord, the penalty. I'm only raising the question, Roman V, my lord, page 12, my lord. Here my revised return rejected and enhancement made only, here the penalty is 4,40,000. Tax amount is only 17,000. And interest 50,000.
Delays condoned. Say notice confined to question 5. Page 12. (22nd March).
From 83. My lords, 83. My lords, Justice Raman was appearing, my lord.
All right. Just before a bench.
Before the tribunal.
83.
83.
It is. No, but he has to tell us what's the tax effect.
No, Your Lordship, it is against advance ruling, Your Lordship.
Adverse?
Advance ruling.
Advance ruling. Okay. Just before a bench, Justice Raman is not a member. All right.
Item 84.
Is it a fresh matter?
Your Lordship.
Oh, on 2nd January. All right.
Item 84.
Here notice has been issued, Your Lordship. Notice have been issued on dated 28/7/2014.
Yes, my lords, we have appeared already.
Requisite to be filed by date and so on, sir. Returnable, Your Lordship. Notice has been issued.
So what we have to admit it, what should happen?
If the question of law is at page 11. Eighty-four. Sorry, Your Lordship, I'm sorry. 84. Before Your Lordship,
Who's for the petitioner in 84? None of you is dismissed.
Item 85. May I please, Your Lordship? Notice I have filed a petition for dispensing of annexure 1 and 2, the assessment order and the first appeal order, my lord. The substantial question of law is start from page 9.
Penalty,
my lords. May kindly turn to page 10. A questions of law has not been admitted. I pray for question 2 and 3, my lords.
Wanted to file documents to controvert the finding. 9/9/2016 order. What happened? Acha.
85.
You've complied with the order dated 2nd March 2017.
Yes, ma'am. 85.
2 and 4, is it?
1 and 2, my lord.
Sorry?
1 and 2, my lords. dispensing of annexure 1 and 2.
No, that's true.
No,
What is the
question.
Question, my lords, 2 and 3, my lords, page 10. May I read, my lords?
All right, you say admit the following questions are frame for consideration. Page 10, 2 and 3. That's it. Admit in due course. List in due course. The interim order passed on such and such date is made absolute during the pendency of the revision. How many more matters are left? Yes, call out.
Item 86, my lord, no instruction.
No instructions dismissed.
Item 87.
My lord, 87, question of law is at page 22.
What's the tax effect, sir?
Tax effect 2 lakhs more. Oh, 2 lakhs. My lord, if you have penalty under section 70.
All right, notice returnable 23rd.
Question of law is 103. My lord, already reported decided. I paid the tax before as per the judgment.
We should notice, sir. We should.
My lord.
Item 88.
88, your lordship, 14,230.
Insignificant tax effect.
Item 89.
Your lordship. Your lordship, here what happened? It is the opposite party, your lordship, the respondent. In the meantime, OCL India Limited has been changed the name to Dalmia Bharat Limited.
So you have to move an application. All right.
Your
lordship. Permitting the petitioner to file an application regarding substitution of the
opposite
respondent.
Your lordship.
List in the miscellaneous board on 4th January.
Your lordship.
For hearing, item 90.
Tax effect is only 12,000.
You have insignificant tax effect. The court's not inclined to defend.
91.
Item 91.
90. Your lordship, super item 91. Your lordship, the question of law. That page 2, it is a reference application. Whether in the facts and circumstances the law and sales tax.
What's the tax effect, sir?
Tax effect is more, your lordship. 10 lakhs.
Has the respondent been served?
10 lakhs 99,000.
Has the respondent been served? What is the DFO?
Your lordship, divisional forest officer.
Come on, sir. This is an internal state.
Your lordship has already decided the case. DFO, divisional forest officer, can be also a dealer.
I know, but it's from this pocket to that pocket. Why should we? The respondent being the divisional forest officer, the court is not inclined to interfere, leaving the question of law open for decision in some appropriate case. The revision is disposed of. All right.
Item 92.
Your lordship, 92.
Lordship, 92. This STREB is against the order of assessment under section 12A, that is the reassessment. Very recently, Your Lordship, the tribunal, full bench of the Honorable Tribunal, by order dated 25th August, has decided the matter against the 4 assessment under the OST Act, Your Lordship, for the very same period.
The same as this.
12-4 sitting or 12-8?
But
Lordship, the question of law is at page 11.
Page?
11.
No, this already seems to be.
Yes, Your Lordship, it is for hearing, Your Lordship.
So we'll keep it on board, we'll take it up.
Yes, Your Lordship. As Your Lordship pleases.
Stay on.
Item 93.
93, Your Lordship. Your Lordship, it is covered, Your Lordship. Divisional manager OFDC, Your Lordship. But with the purchase value, the question of law, Your Lordship may kindly turn to.
Royalty is not includable in turnover.
Exactly, Your Lordship. It has already been decided in that Guru value case, Your Lordship, that royalty can be a purchase value, Your Lordship.
No, so it goes against or in favor?
In favor of the revenue.
All right. In
Shall I-
view of the
shall I submit this
decision
as-
of this court. Who was given this? Who's for the opposite party? Somebody for the SSC has given another judgment.
Your Lordship, I'm just.
All right, it will stay on board, sir. Right.
Item 94.
Stay on board.
My lord.
94, your Lordship, identical matters 28, na?
No.
Achha, sorry.
My lord, by order dated 3/11/2016, your lordships has admitted the questions of law. May I read the question of law?
We'll keep it on some other days.
Yes, my oblige, my lord.
Stay on board.
Right, my lord.
Your Lordship, this identical issue, for that reason I am questioning. Your Lordship, may kindly turn to page 11. The question number B. The question number B, the identical matter.
Only one question admitted. Already
Yes,
in
yes,
order
sir.
admitting. There's already an order admitting this matter, sir.
Already admitted, my lord.
No, question, your Lordship, Uttar district.
No, that is not the case here.
28A.
That identical issues are fixed on 2nd February 2013.
23.
Your Lordship.
All right, list on.
My lord, this is not the case, my lord. My lord, in this case, credit notes were issued, not the credit notes as provided under section 21 or 22. These credit notes were issued. Your losses by kindly.
All right, stay on board. All right.
Item 96. Item number 96.
Your Lordship, 96, 18,148.
Insignificant tax effect. 96.
Item 97.
97 is covered by Chandrakant Jayantilal. Your Lordship has decided that 40-5 penalty. Already decided, but nobody is there.
None appears dismissed.
Item 98.
98 minutes. So the question of law has been admitted by order.
Then we'll take it on some other. Stay on board.
Item 99.
99 the same. 2nd February 28.
My lords, that might be kept on board, my credit note regarding credit and debit.
List along with
WPC number 21,894 2012 HPC Limited 2nd February 2013.
All right.
28.
Item 100.
My lord, question of law is at page 14. My lord,
admitted already.
Admitted. This is 40-5 penalty, your Lordship.
My lord,
your Lordship has already decided, Chandrakant.
My lord, I am not on the verge of that. I am the question number 2. Whether on the facts and the circumstances of the case, the tribunal has right in confirming the imposition of maximum penalty when arbitrarily the petitioner has excess carry forward ITC, refundable for an amount of which proof.
Your Lordship,
my lord, page 8 of the assessment, page 26, assessment order may I will look in.
All right, we'll stay on board. We'll stay on board. All right.
Grateful, your Lordship. Obliged.